Ooh. How's our memers doing today?
President Trump is practically and morally responsible for provoking the events of the day. President Trump is still liable for everything he did while he was in office as an ordinary citizen. Unless the statute of limitations is run, still liable for everything he did while he was in office. Didn't get away with anything yet. We have a criminal justice system in this country. We have civil litigation. And former presidents are not immune from being accountable by either one. President Trump is practically and morally responsible.
Based. Huh. What's the takeaway from last night for Smooth Brains? Is the president too powerful now, or are we fine? Well, I think the two huge things that are going to have to be determined now in future litigation is one is going to be what counts as an official act. That's who the fuck knows, because I don't think the Supreme Court gave any guidance on that. No, that's probably going to be the big one. It's going to be what counts as an official act. And what's going to be the test for figuring out if the president has like acted in an official capacity or not. Is the lower court going to have to determine that now? So here's what of the 4 things that were brought up in the major opinion. The conversation that happened between Donald Trump and his attorney general. Well, maybe I'll finish reading this first. 'Cause we only got 2,000 people in here. I'll go over it.
This is the last year of a lame duck president. And if Ted Cruz or Donald Trump get to be president, they've all asked us not to confirm or take up a selection by President Obama. So if a vacancy occurs in their last year of their first term, guess what? You will use their words against them. I want you to use my words against me. If there's a Republican president in 2016 and a vacancy occurs in the last year of the first term, you can say, Lindsey Graham said, let's let the next president, whoever it might be, make that nomination, and you could use my words against me, and you'd be absolutely right. We're setting a precedent here today, Republicans are, that in the last year, at least of a lame duck 8-year term, I would say it's going to be a 4-year term, that you're not going to fill a vacancy of the Supreme Court based on what we're doing here today.
So unbelievable.
That's going to be the new rule. When y'all change the rules about appellate judges and district court judges to get your way, I thought it was a really abuse of power. And what you have done here is you've made the caucuses, the Republican and Democratic caucuses, are now not going to have to reach across the aisle when it comes to appellate judges and district court judges to get input from us or we get input from you. So what does that mean? That we're going to pick the most hard-ass people we can find and dare somebody in the conference to vote against that person. You're going to have the most liberal members of your caucus pushing you to pick the most liberal judges because you don't need to have to reach across the aisle to get any of our input. And we'll do the same. So over time, the judiciary is going to be more ideologically driven because the process in the Senate now does not require you to get outside your own party. So I'll be fighting talk radio when somebody on my side puts up a nut job, and they will. And I'll fight if I think they're truly a nut job. That's going to happen on your side, too.
Bezda. Has Lindsey Graham ever been married? I don't know, but I think you can get married now, right? Didn't the Supreme Court say that was okay?
I want an ice cream. How quickly would I... That sends an ice cream. Oh, shit.
Did somebody say bathed? Lindsey Graham, 4 years later.
Any reasonable person could impose in terms of qualifications. I think you made every test in terms of disposition and character that the public could hope for in terms of having somebody sit at the table at the Supreme Court. You will be confirmed, God willing. You will have my full support. I see in you someone who's not only highly qualified to be in the court in every way possible, but somebody that has broken new ground in a positive way for the country. So what we will be doing now is go in closed session. The FBI evaluation will be presented to the committee. That's standard practice for every nominee. We will meet again here just in, where's the room? Dirksen G50. You will be with us. We do this for every nominee going back to Chairman Biden. And it is over. The hearing part is over. You can have 2 glasses of wine tonight if you like.
Mr. Chairman,
Yes.
I'll defer to Senator Durbin if he wants to go first.
Yes, I would just like to finish my thought, then we'll defer to Senator Durbin. The hearing part is over. You acquitted yourself well. But the journey you're about to take is going to be challenging. It's going to be rewarding. And may God bless you in this endeavor. Senator Durbin.
Mr. Chairman.
How was that steam iron you got? I haven't even gotten to open it yet. Speaking of, hold on. Does this work? Let me check. Okay. Based. Or is it Bayzed? I don't actually know. Don't know. Don't give a fuck. It's Bayzed? How does that even make sense? Would you talk to peers outside of a show? Not at all.
But you have to go home now. We have to have peace. We have to have law and order. We have to respect our great people in law and order. I know that everyone here will soon be marching over to the Capitol building to peacefully and patriotically make your voices heard. We have to have peace. So go home. We love you, but go home and go home in peace.
Just in case you weren't aware of it. When Trump was giving this speech,
Ladies and gentlemen.
Legal in Wisconsin, meaning that this could be happening to our Constitution. Democrats have gotten away with.
there's no transcript on this video. I don't know why. So now we're painfully.
Election for people that tore down our nation. The weak Republicans, and that's it. I really believe it. I think I'm going to use it. Joe Biden said, I want to get rid of the America First policy. What virus and the scam of mail-in ballots. Democrats attempted. don't forget when Romney got beat. Romney, did you see his? I wonder if he enjoyed his flight in last night. But when Romney got beaten, you know, he stands up like your more typical. Well, I'd like to congratulate the victor. The victor. Who was the victor, Mitt? I'd like to congratulate. You can go all the way back. You know, America is blessed. Free and fair press. Our media is not free. It's not fair. It suppresses thought. It suppresses speech. And it's become the enemy of the people. It's become the enemy of the people. It's the biggest problem we have in this country. No third world countries would even attempt to do what we caught them doing. And you'll hear about that in just a few minutes. Republicans are...
I didn't catch this when I first listened to this speech because I didn't know what was being schemed. Somebody in the subreddit pointed this out, though. It was very interesting. Hold on.
Republicans are constantly fighting like a boxer with his hands tied behind his back. It's like a boxer. And we want to be so nice. We want to be so respectful of everybody, including bad people. And we're going to have to fight much harder. And Mike Pence is going to have to come through for us. And if he doesn't, that will be a sad day for our country. Because you're sworn to uphold our Constitution. Now it is up to Congress to confront this egregious assault on our democracy. And after this, we're going to walk down, and I'll be there with you. We're going to walk down. We're going to walk down anyone you want, but I think right here we're going to walk down to the Capitol. And we're going to cheer on our brave senators and congressmen and women. And we're probably not going to be cheering so much for some of them. Because you'll never take back our country with weakness. You have to show strength, and you have to be strong. We have come to demand that Congress do the right thing and only count the electors who have been lawfully slated. Lawfully slated. I know that everyone here will soon be marching over.
I don't think anybody knew really what this meant when he said this, but I realize now, and going back and looking over this speech, he was explicitly calling for that. He's referring to the electorate scheme here. That's what he's doing. But nobody's even cheering because nobody actually even knows what this plot is. It wasn't publicized very much. I think there was a leak prior to the speech, like the Eastman memo, but nobody really knew. I didn't, at least. And it doesn't seem like it was getting much airplay for what the Eastman memo and everything was about. But this is him explicitly referring to that. We have come to demand that Congress do the right thing and only count the electors who have been lawfully slated. And the idea was that Mike Pence was going to have to come through for us, meaning that Mike Pence was going to have to be the guy to toss the actual electorate slates and just count the ones that that Trump had the 7 different groups of people perjure themselves and say that they were the real electorate slates. Yeah, I didn't realize before that. So I didn't remember, but this is explicitly calling that out. That's hilarious and kind of sad, but.
And only count the electors who have been lawfully slated. Lawfully slated. I know that everyone here will soon be marching.
How would Pence change anything if he is lawfully bound to acknowledge the approved electors? What Eastman and Donald Trump hoped to do in his attempt to soft coup the government, what his goal was there were supposed to be 14 different slates of electors that show up for 7 different states. And Pence was supposed to feign ignorance and go, well, I don't know which ones are the real ones. There's supposed to be a small debate in the Senate over what the real ones are. And then Pence, I think after an hour, it's written in the Electoral Bullshit Act or whatever, has the ability to call time and say, sorry, guys, we don't know who the real electorates are. right? Well, Pence could have just said, actually, I trust these. He could have just not opened the other ones and said, fuck it. But if you wanted to take it a step further, you go, oh, well, we don't know who it is. So we're going to throw it back to the delegation in the House of Representatives, and the House delegation is going to get to vote on who the president gets to be. Now, because the House delegation is split up just by states and not just by representatives, the Republicans have a majority technically in the House, even though the Democrats have more seated members. So the Republicans can declare Trump the president from the House because more individual states are represented in a House delegation when it comes to voting for president. So they could have basically made Donald Trump the president in the House after that. But when he wanted Pence to come through, these were the two ways that Eastman was theorizing the election could theoretically be stolen. Theoretically, yeah. Wait, this was actually way too close to working out? Yeah, I said this on election night, seriously, but not realizing how true it was, that like Pence was what stood between us and oblivion, but in more ways than just refusing to call the election on the night of because Donald Trump didn't want the votes counted. Yeah, Pence could have theoretically just said, oh, yeah, we're not going to count these electorate slates, we're going to count the other ones. In order to delay, they need the consent of both the House and Senate. Pence had no legal authority to delay unilaterally. Are you sure? Let me check. The Eastman memo. I thought Eastman, I think, had a weird theory for why he might be able to do that. Let me check real quick. Oh, so Eastman's theory hinged on the idea that the Electoral Count Act was likely unconstitutional. He believes that this act wouldn't survive a challenge in court. And he's saying, so I think what you just said, I think might be provided in the Electoral Count Act, but Eastman believes that it's not constitutional. And he says, here's the scenario that we propose. One, VP Pence, presiding over the joint session, begins to open and count the ballots, starting with Alabama, without conceding that the procedure specified by the Electoral Count Act, going through the states alphabetically, is required. When he gets to Arizona, that's the first electorate slate that they faked. When he gets to Arizona, he announces that he has multiple slates of electors, and so is going to defer decision on that until finishing the other states. This would be the first break with the procedure set out in the Act, in the Electoral Count Act. At the end, he announces that because of the ongoing disputes in the 7 states, these are the 7 fake electorate slates that Trump had his cronies send, there are no electors that can be deemed validly appointed in those states. That means the total number of electors appointed, the language of the 12th Amendment, is 454. This reading of the 12th Amendment has also been advanced by Harvard law professor Lawrence Tribe. A majority of the electors appointed would therefore be 228. There are, at this point, 232 votes for Trump, 222 for Biden. Pence then gavels President Trump as reelected. So it also relies on an alternative reading of the 12th Amendment to make this work as well, which would also probably have to run through the court. Because I think the 12th Amendment might require like a minimum amount of electoral votes, and if nobody gets it, theoretically there's no president or something. I don't remember this exactly. But they were going to read it basically another way. First time the greatest number of votes for president shall be the president. If such number be a majority of the whole number of electors appointed, and if no person have such a majority, then the persons having the highest number not exceeding 3 on the list of those voted for its president, the president shall choose immediately by ballot the president. Something like this. Howells, of course, from the Democrats, who now claim, contrary to Tribe's prior position, that 270 is required. So Pence says, fine, pursuant to the 12th Amendment, no candidate has achieved the necessary majority. That sends the matter to the House, where the votes shall be taken by states, the representation from each state having 1 vote. Republicans currently control 26 of the state delegations. The bare majority needed to win that vote. President Trump is reelected there as well. Because in the House, it wasn't just by number of representatives, it was by state delegations. That's important, okay? One last piece, assuming the Electoral Count Act process is followed and upon getting the objections to the Arizona slates, the two houses break into their separate chambers, we should not allow the Electoral Count Act constraint on debate to control. That would mean that a prior legislature was determining the rules of the present one, a constitutional no-no, as Tribe has forcibly argued. So someone, Ted Cruz, Rand Paul, etc., should demand normal rules, which includes the filibuster. That creates a stalemate that would give the state legislatures more time to weigh in to formally support the alternate slate of electors. That's the fake one, the fake 7 that were given by Donald Trump, if they had not already done so. When you say fake electors, you mean 6 different people pretending to be electors, or they just fake documents? They faked all of it. So the way that it works is in each of the 50 states, after your votes have been counted, the state procedures typically nominate they'll nominate some people to serve as the state electors. And what the electors do is they get together and then they write and they sign a document where they transmit it to NARA and to Congress. And they say, hey, this is how our state voted. Here's where our electoral votes are going. We attest to this under penalty of perjury that we are the duly appointed state electors. And here you go. Donald Trump had 7 different groups of people fake that certification and also transmit their votes to NARA and to Congress in order to cause confusion. That was the goal, basically. Nothing that I'm saying is none of this is like, well, I mean, you could say it's alleged. I mean, it's possible that all of it was faked. But the actual paperwork that the people all perjured themselves signing is all public.
Now,
so wait, who were those
these
people? They were just like private citizens that basically Trump's campaign got together to campaign got them together to just falsely certify that they were the electors that were appointed in their states.
Republicans also prepared forged fake documents that were sent. Just watch this. Tell me if you notice something as I show you these. And that's the fake one on the right. Here also is Wisconsin, where we reported on their forgery last month.
So here on the left, this would have been what Wisconsin transmits to for their electoral vote, and then on the right was the fake one that is signed. Basically, everybody that was involved in this perjured themselves. They said, "We, the undersigned, being the duly elected and qualified electors for president and vice president of the United States of America from the state of Wisconsin, do hereby certify the following." They lied about where they met. That we convened and organized at the state capitol in the city of Madison, Wisconsin. They didn't. A lot of these people were turned away. Fake electors try to get into building. Did the electors know they were lying? Yes. None of this is contested. All of this is just very, yeah, nobody. How have I not heard about this before? Because nobody talks about it, because nobody knows how our election system works. Nobody knows how our electoral systems work. Nobody has any idea. So how would you even know? How would you begin to understand this? Nobody knows. Nobody has any idea. If I went on a Tim Pool show, I would only argue the elector scheme for 2 hours until he concedes to all of it. And he won't concede to any of it, and I'll just go over the details of this over and over and over and over and over again. How is this not proof of a coup? It is. It is a coup. It's not even... No, I'm sorry. I'm so sorry. It's not a coup. It is an insurrection, because the final point of this coup attempt was a violent march on Washington. That was the final point of this. It was an insurrection, right? This was the legal part that had been satisfied to where they had all of the shit that they needed to have all the paperwork in line. And then the violence on the day of was supposed to pressure everybody in the Capitol building to go ahead and certify the other slates of electors. That's why Donald Trump invited all of his people there. That's why he gave the speech saying, we need to make sure, guys, we need to go here and we need to make sure we have come to demand that Congress do the right thing and only count the electors who have been lawfully slated. We have to show strength. You have to be strong, right? The whole point of him inviting his crowd there, the whole point of them marching to the Capitol building was for them to pressure the congressmen, which is also the phone calls that Trump made when they were all cowering and when he was calling people and when Giuliani was calling people. They were saying, just certify the fake electors. That's what this was. But anyway, yeah, this is a video of some of the fake electors, I believe, trying to...
So you're telling us we can't enter? Yes. Okay, would you say that on the What did he say? He said we can't enter.
What I said was, for the Capitol Commission, for the governor's office, for the Speaker of the House, for the Speaker of the Senate, the Capitol is closed unless you have an office here to conduct business today, or if you are taking part in the Electoral College process. Anybody else is not permitted to come in.
They're here to take part in the electoral.
These aren't electors. They weren't appointed by the state, and they're all lying when they say this.
Electors are already here. They've been checked in.
They're also elected.
Capitol's closed. All 16 electors that we've been advised by the governor's staff that we're going to be here to vote in the electoral.
Did any of the fake electors get perjury charges? I think that some of them might be roped in the Georgia RICO case. I don't know if they're targeting the fake electors or just the people. I think it was Chesborough or Chessman. What the fuck is the guy's name? I don't know if they went after the. In Arizona they got charged. In multiple states there were charges. Oh, okay. Maybe in some states they have charged him then. Is it Kenneth Chesborough? Did the Supreme Court ruling basically say his involvement in this is considered official duty? Who knows? When Trump was talking to his attorney general, his acting attorney general, Donald Trump told the acting attorney general, he said, you need to send letters to the states, these 7 states, and say, hey, we've got huge evidence of voter fraud. You need to flip your electoral vote. And the acting attorney general, it was either Rosen or Clark, he said, no, we're not going to do that because obviously we have no evidence of this. And Donald Trump said, I'm going to fire you. I'm going to make this coffee dude the attorney general then. And this part is unconfirmed, but apparently half the staff in the White House threatened to quit. Like, this isn't happening. Or almost all of his White House staff threatened to quit out of this. And he's like, okay, fuck it. So he didn't do that. That conversation, though, where Donald Trump is talking to his attorney general about who he can fire and who he can hire, that is a core power of the president, meaning it is exclusively his. And the Supreme Court has ruled that that conversation is granted absolute immunity. Doesn't matter what he said, doesn't matter what it was for, doesn't matter what it was right or wrong. It is above judicial review. It will never, ever, ever be a part of any sort of criminal indictment, and it is beyond being reviewed by any legal body as criminally indictable. So that's completely off the table. Anybody that tells you differently didn't read the decision, or they didn't understand it. Now, the next thing had to do with pressuring Pence to flip the electoral vote. When Donald Trump is talking to Vice President Mike Pence about the electoral process, that is a power that is granted to the President of the United States and the Vice President. However, because the Vice President is serving as the President of the Senate, there's some overlap there between the presidential powers and the congressional powers, but because there's overlap and it's still part of the president's powers, he's given presumptive immunity, meaning the assumption is going to be that he's probably immune unless the government can argue against his immunity in this case. However, that argument against it is a pretrial motion. It's not an affirmative defense that Trump has to use in court. It's something that the prosecution, in this case the state, has to overcome before you can even get to a trial process. It's part of your pretrial motions. So you can you can do a motion to dismiss based on immunity, and the government has to overcome that burden. Nobody knows how yet, because I don't think there was a way given to figure out how that works. So whether or not pressuring Pence counts as an official act or not, we do not know. Conversations with state officials to flip their electoral votes. The lower courts haven't done a fact pattern analysis yet, or fact analysis yet, or even given an argument for if that was official or unofficial. So the Supreme Court remanded that to the lower courts, and they said, figure out, go do the facts, and then come back to us, because the Supreme Court is a court of last review. It is not a court of first review. The Supreme Court will not consider novel facts in front of it. That has to be dealt with by the lower courts first. And then the speech made on January 6th to rally supporters was given the same treatment. There wasn't a fact analysis done on that to determine whether or not it was a core power of the president, like an official act, or if it was an unofficial act. So it was remanded to the lower courts for them to decide that. So two parts of that indictment were remanded to the lower courts for an analysis. A third thing was remanded to the lower courts, basically for them to argue against the presumptive immunity. Why shouldn't Trump have immunity there? And the conversation between Trump and his acting attorney general is completely off the table. He's been granted absolute immunity for that. Can you further elaborate to viewers about the need to examine motive and how preventing us from examining motive makes this incredibly difficult? Not yet, because I don't think I've reached that part of the decision yet. I think we were a little bit over halfway done. I'm sure that that's probably brought up by the dissent, but we haven't read the dissent yet. What is the Trump defense about the fake electors? Did they just deny it? They just said they were legal. They don't even talk about it. Nobody even knows how, It's not a question of whether talking to Pence was an official act. It's a question of whether or not granting community would weaken the authorities or function of the executive. I think that the argument, I think that's dealt with in the ruling. I think they say that anything that is going to make a core power criminally indictable would weaken the authority or executive or function of the executive. That's why the exception they give is if Congress has an overlapping power. Yeah. All of the core presidential powers that are exclusively granted to the president are beyond judicial review, beyond criminal review. That was the novel thing that we got from this Supreme Court case, that all core acts taken by the president as official acts that are part of the core power of the president are beyond criminal review. Nobody is allowed to review those acts in a criminal matter ever. Destiny's hatred for Trump stems from the rebellion against his mom. So pedantic. Okay. Sorry, hold on. I will call these out. Somebody in YouTube chat said judicial, but not congressional. Wrong. Congress can never, ever, ever make somebody criminally liable. Congress can only impeach somebody. Impeachment is a process to remove someone from office. Start and stop. That's it. That's all impeachment can do. Impeachment is not there to criminally prosecute somebody, although for confusing fucking reasons, a lot of the language is the same, and they treat it like a trial, kind of. They use a lot of overlapping language. However, impeachment is only for removing somebody from office. It is not for holding somebody criminally liable. Somebody could impeach you for raping somebody, and you could be convicted in the Senate for rape, but it doesn't matter. There's no the only thing they can do is remove you from office and make it so you can't hold future office. Can you explain to me how separation of powers is related to this? Isn't the executive the branch that charges crimes? How is an executive charging the executive a separation of powers issue? Executives are tasked with carrying out the faithful execution of laws passed by the legislature, Congress, but the judicial branch is who makes people hold to account for their crimes. However, I don't think there's a separation of powers issue here because I don't think it's a separation of powers. I don't believe that the criminal prosecution, I don't believe is a check on anything. I just don't think that I don't think criminal charges or criminal conviction is thought of as a check on power of any of the branches of government. But my government history is not the best, so maybe, I don't know, maybe it was, even though there's absolutely no writing in any single part of the entire history in any of the text or any of the history in any of the laws of the United States, because if it was, they would have referenced it at least one time, and they didn't. So there are no references like that, but yeah. Is this shit super complicated, or am I stupid? Everything in law is complicated when you only have one or two pieces. But in my opinion, this is how I felt reading U.S. law. This is how I felt reading international law. The legal system starts off like this. You look at it and you're like, I think it kind of makes sense. And then you dive into it a bit and you're like, this is convoluted and fucking weird as fuck. And then when you get into it more, usually everything makes a lot of sense. Things are set up the way they are for reasons where it's like, oh shit, this is actually, there's a really good argument. Fuck, reading those Federalist Papers yesterday was pretty base. These guys were really smart in their design of government. The United States is not a government that sprung up and happened or didn't evolve out of other systems. The United States was incredibly intentionally put together from start to finish using a historical and contemporary analysis that combined theory and empirical, evidence of how governments have functioned in order to put together a government that not only functioned well, but was adaptable and responsive and dynamic going forward. That's why the United States, I believe, has the oldest surviving constitution, full constitution. Fuck out of here with that Magna Carta bullshit. Full constitution that is the bedrock of a government of any country on the planet today, even though it's a relatively new country. Most of the legal stuff that I've come across, most of it makes sense. Even stuff that I've historically said, God, like, why do we have like strict liability crimes? It's so stupid. Like, even stuff that I thought was generally dumb. Like, once I've gotten a different explanation for it, I'm like, oh shit, yeah, that actually makes a lot of fucking sense. I get that. I understand that now. Yeah, 100%. Yeah, generally how it goes. Yeah. Isn't the main distinction the Supreme Court made is between unofficial and official acts? Never in the history of the United States of America, I would argue, with limited historical understanding, but based on the arguments I've seen the Supreme Court put forth, on the little we've read of Thomas, who is going on a schizo ramble right now, and then what I read of the Roberts, who penned the majority opinion, I do not believe that any president in the United States has ever operated with the assumption that he was immune from criminal prosecution. I don't believe that. I don't believe that. That's why I don't think there is a worry that you can make that if you criminally indict a president, that it would lead to the destruction of the country. Because I think presidents have always operated like they were worried about potential criminal indictment. I think that's all. I don't think any president has ever acted or thought that he was above the law. I don't believe that. But I could be wrong.
College, you've been checked in, we're already here.
But these are the rest of the electors.
I understand, but the Capitol is closed, everybody has permission to come forward.
Captain, the electors are also, the GOP electors are also on the governor's certificate of ascertainment.
I'm not going to get into a political debate. I'm following orders.
It's not a political debate. Okay. It's the official sealed document. The certificate of ascertainment has...
Official sealed document? He's lying. He doesn't have an official sealed document. He has a perjury. None of that is true. He is not duly elected. None of these people are. These are part of Trump's scheme to get a fake set of electors into the Capitol building. The reason why they wanted to go in the building is so that they weren't perjuring themselves as much and so they could cause more confusion, so that they could be more easily confused with the actual appointed electors.
Also, the GOP electors, they are here. They're trying to do their constitutional duty.
I understand.
And their constitutional duty requires them to be at the Senate chamber today at 2 p.m.
Okay.
They're here.
All right, they're not...
The core powers have always been thought to be non-regulatable by Congress. There is existing precedent for that already with respect to the firing of federal employees. I agree with you, and I think I would agree with that statement. I agree that core powers, constitutional powers granted to the president, are so strong, in fact, that Congress can't even pass laws against those. I would agree with that. That is a good argument, but I don't think anybody's arguing against that. Why the fuck would the legislature have the ability to dictate to the executive things that are granted to it by the Constitution? The Constitution supersedes both of these bodies. However, two things. If Congress wants to change what the president does, that needs to be done through constitutional amendment. You have to change the actual Constitution. And the Constitution, remember, is the original Constitution plus all the amendments. That's constitutional law. All of that is, okay? However, I don't think that criminal review of criminal actions that are taken by the president count as the legislature or the judicial reviewing executive actions. I believe that those are meaningfully different. So, for instance, if the president pardons somebody and Congress is like, actually, fuck you. We don't want that person pardoned. We think that guy's an asshole. You're not allowed to pardon that person. Fuck you. I think that rightfully, in the first court, that would get struck down. You go, sorry, Congress, kick rocks, eat shit. You don't have the ability to limit the power of the president on that. You can't do that. That's his power that's granted by the Constitution. However, if the president goes on live TV and he says, here's my Bitcoin wallet. If I've got $20 million by the end of the day, I'll pardon, XYZ federal criminal. Let's see what happens. Then, he gets some money. Cool, I'm going to go pardon it. And a judge or a prosecutor says, excuse me, sir, you just took a bribe. You can't do that. I don't believe, as it's argued by Roberts, that counts as judicial review of a core power of the president. I don't believe that's to be the case. I think that he's committed a criminal act that is not a core power delegated to the president. A very plain reading of any part of the Constitution, of any of the Federalist Papers, of any part of the framers discussing our Constitution is never going to grant you this idea that the president can commit crimes with his core powers, okay? So if you want to say that he's committed a crime, that's fine. Now, the argument that Roberts and the court is floating is that, well, if you can review these actions criminally, then essentially you basically are reviewing them like in practice, because now now Congress or the judicial can just charge him with a crime or not convict. Charge him with a crime. Basically, the judicial can charge him with a crime every single time they don't like what he does. However, if you want to say that, you can run with that argument, but man, that is a scathing indictment of our federal justice system. So you're saying that all criminal indictments are bullshit? You're saying the grand jury system is bullshit? You're saying that we can't rely on any part of our judicial system to deliver us like fair and decent indictments? Now, Roberts' counter argument to that is maybe they can. However, in the case of the presidency, the office of the presidency is so exceptional and so special that sure, the federal system will work fine for criminal indictments for an ordinary citizen, but for the president, who might be making historically unpopular decisions, do you really want a president who has to make a decision on whether or not he's going to keep this country safe to have to think whether or not he'll face criminal prosecution for it? The president has a unique role, and he's vested with unique and exclusive power in the Constitution. He's not above the law, but some things should be beyond review because we don't want him second-guessing himself, because the judicial system can put unique pressure on him. Now, the counter, whatever the fuck argument to that I wish I would have seen addressed here is, okay, fine, that is true, that the president might have a unique set of circumstances that make it so that he might have a more difficult time in the criminal system. However, criminal crimes, not civil matters, but crimes are not just an interest between parties. Crimes are a state interest. The state, every individual and the state has an interest in not allowing crimes to happen. And I would argue that for the president, we have an extra special interest, not just in each individual state, but in the United States, in this country, to not have a president committing crimes. So while I agree that there might be undue burden or a potential undue burden on the president, there also should be a higher expectation that this is not a fucking criminal in office. He's not a criminal president. That's also a very high burden. And what I don't like is that all of the citations that we've been given in Roberts' opinion, I'm reiterating this because I haven't got the next two, all of the citations that we've been given are to cases, especially that Fitzgerald case with Nixon, are to cases that talk about how, well, the president shouldn't be liable for court stuff. He shouldn't be liable for court stuff. He shouldn't be liable for court stuff. He should be liable for court what? For civil damages. For civil damages. And the argument that Roberts makes that, well, if he can't be held liable for civil stuff, obviously he can't be held liable for criminal stuff, right? Criminal's even worse than civil. Sure, but there's a much higher burden of proof on criminal stuff. It's not easy to say that one is categorically necessarily worse for the other, depending on your situation. Like I said before, if I was running a business and you were to tell me, okay, Destiny, you just got one wish from a genie lamp. Do you wish to be immune from all criminal prosecution, or do you wish to be immune from all civil litigation? I would say, make me immune from civil litigation. The fuck? I'm not going to be committing crimes. I don't want to murder or rape somebody. I'm not going to do something against the law. But you can make me immune from all civil litigation? I can't be held liable for any damages to any fucking person ever? Bro, you can get sue people for that shit any day. Anybody can be a plaintiff in a fucking civil case. Fuck that shit. Hell yeah. And you only need 51% to win those cases. So hell yeah, make me immune from civil litigation. Do I need to be immune from criminal matters? No, there's a much higher burden there. It's harder to get an indictment. It's much harder to get a conviction. Criminal stuff is separate. I don't like the conflation between the criminal and the civil stuff. But that's just my uneducated opinion so far. Heel Shit Podcast, thank you for the 5 subs. Isn't this the first criminal case against a president ever? Yes, there's one argument that's commonly floated about that, but there is a counter argument that I've never heard floated. So one side of the aisle will say, this is the first criminal case ever, okay? Imagine how horrible it would be if everybody started doing criminal cases against presidents. That's one argument that you could float. However, I feel like I could just as easily give the counter, hold on, This might be the first president that's overtly committed criminal acts because presidents have operated under the assumption that if they do this, they will be held criminally liable. Imagine a future where presidents now think they can't be. Like, if you were to go back historically and poll the presidents, hey, just curious, if you committed a criminal act as part of, like, being the president, do you think you could be, like, charged with a crime in the United States? Most of them would probably say, in, like, most cases, yeah, probably. Maybe not, like, for actions taken as, like, commander-in-chief or, like, wartime stuff. Maybe there might be some exception. But for the most part, they'd probably say, like, yeah. Otherwise, my assumption would be, why the fuck would Nixon resign? Like, who cares? Make sure that the people you're ordering to fuck around are just like people that are in the executive, and yeah, you're just having conversations with them about shit that they, could be doing anyway, right? Well, I'm gonna be honest. I don't even know what the fuck Watergate was. What was it? Just like putting cameras or stealing shit from like the offices of the political opponents. Just tell the FBI to do it. That's the FBI literally exists under you. It's an office authorized by Congress. You're allowed to fill it. You're allowed to staff it. You nominate the head. Like, just talk to the head of the FBI and say, go investigate that and go fuck them up. That's part of your core powers as president. You can't be held criminally liable for whatever you talk to the FBI about, and you're above criminal review. You're above criminal review there. Maybe somebody in the FBI, gets fucked. Maybe get impeached. You can't be fucking charged with a crime. I think Nixon, though, thought he could be charged with a crime because Ford pardoned him, which some would argue is an implicit admission of a crime. No, I've never settled that. I haven't read into that, but I admire how much of an institutional simp Destiny is. EMAD, if it wasn't for our institutions, you wouldn't fucking exist. The whole internet that you use, okay, has come from the institution of our defense industry operating as a coherent entity and investing in new research and technologies. Literally no part of your life, okay, would exist right now without the institutions of this great country. Eat shit and die, okay? I know this is off topic. I want to make sure Dan doesn't buy shielded XLR cables for fixing the buzzing problem on one mic. We can go into detail, but it's a big scam in the audio world. Okay. Okay. How is a crime committed by the president a state issue? This should exclusively be a federal issue. No, not necessarily. States have crimes. The federal government has crimes. People can commit crimes in different states. They can be held liable in different states for state crimes. Just depends on what you're doing. Do you think this will change the pool of future presidential candidates while they try to test the law? Maybe. Why wouldn't you? My understanding is that Donald Trump's attorneys are trying to do that now. I think they're trying to say that I've only seen like things posted in chat, but I think they're trying to claim now that, oh, well, actually, hold on. These other things that we were charged with, these were official acts. The fake elector scheme, this is an official act. If his legal team is able to argue that any part of this elector scheme was an official act, not only is that beyond criminal review, it also can't be considered in any other part of the trial as well. So technically, for Donald Trump's legal team to beat the Jack Smith case, they don't even really have to beat every single thing. If they can just pick enough things out of it, you kind of lose the cohesive elements that you could even use to make the case against him. Like right now, none of the conversation, like in my opinion, the conversation between him and his attorney general, like not only, fuck me, I'm so irritated. I just realized this. Not only would that conversation be above judicial review, we wouldn't even know about it, because the only reason we do know about that conversation is because of it being reviewed, essentially. That January 6th commission probably wouldn't have had the ability to do any sort of investigation there, because all the subpoenas would die or wouldn't be authorized, and the indictment wouldn't have gone through on that particular thing because that was a core power. So we wouldn't even know about that conversation. Off topic, but I saw you say on Piers Morgan that the president gets to place people on the court. Do you not agree the Constitution says the president nominates and then the Senate confirms? Why would I not agree when you've just restated part of my position? What did I say that makes you think I disagreed with that? And what do you think you're saying that is countering anything I've said? Can this decision be reversed or irrelevant in any way? A Supreme Court Supreme Court in the future could overturn this decision, or Congress could pass an amendment, a constitutional amendment changing it. Those are the only two ways. Can you give a steel man for this decision? I really can't understand how even a partisan could claim, a partisan court could claim this is constitutional. Yeah, the steel man, you should be able to steel man. Listen, Supreme Court justices might make, in my opinion, wild fucking decisions, but they're always going to have some argumentation or backing. They publish so much shit. These guys write so much. They love writing. They're writing pedophiles. Basically, the steel man argument is when the United States of America's government was conceived of, we were given a legislature. I'm borrowing a lot from, I think, Federalist Paper 69 and 70 here. The legislature was created. The legislature is supposed to be slow and bogged down, and there are supposed to be multiple people on it that disagree with each other. And that disagreement is good, okay? There is a goodness to the fighting on the legislature. You want these guys disagreeing with each other. You want these guys debating each other. You want these guys to have these huge arguments over what legislation should look like. You want it to be slow, okay? You want that to happen because that's a good legislature. They should be debating that in that tension, something great is created, which is hopefully legislation that represents, the legislature which is elected by the people as best as possible. However, now that the law is passed, when the law is given to the executive, there is a reason why in the United States of America we have one man, one unitary executive who is entrusted with that power. And that's because when it comes to the execution of law, you don't want there to be multiple people with co-equal power. You want there to be one man or woman that says, this is the law, this is how it's going to be done. Boom, that's it. Having a disagreement on the executive level, having a disagreement with your magistrate, is what they would have called it back then, having a disagreement with people that are supposed to execute the law makes you look weak, makes you look feeble. It makes you look like you don't know what the fuck is going on. It arouses doubt in the minds of your constituents. It's a horrible deal. So you want the executive, a quote used often by Roberts, the framers envisioned an energetic and vigorous executive. When you make the executive's actions, especially core actions that only he himself as the president can take, when you make those actions reviewable by a criminal court, what you essentially tell the president is, listen, when you're making decisions on how best to execute your function as the president of the United States, when you make that decision, you should be thinking about what is the best way to execute the law for the best outcome for your country. You don't want them thinking, well, fuck, but if I do it this way, somebody might come at me with a crime. You never want the president to be thinking, not in the best interest of the country, but in his own personal best interest to avoid criminal charges. Maybe there's a hard decision that needs to be taken that might result in something that an ordinary person would be charged with a crime for, but the president thinks that it's the best way to faithfully execute the laws passed by Congress, or he thinks it's in the best interest of his exclusive role in something in the president for the execution of his role. You don't want him to be second-guessing himself and for him to be making decisions for his own personal safety because of criminal liability. So that's why the Supreme Court has argued when the president is acting in an official act, especially as part of those core powers, it should be beyond all judicial review, criminal review. That's like the Roberts steel man. Do you think that Shapiro would still argue that the guardrails are stronger than Trump? Opinion now that GOP policy is actively removed. The initial argument that he made was dumb. I don't know. Can you come up with an example of that? Not saying there isn't. It's just hard to conceptualize. I don't know. Not really, no. And they don't really give any examples either. Maybe they come in more in concurrent opinions. Who will decide the result? Is it a judge or jury? Is it possible that in defiance, a judge would say it was a crime knowing the gravity? No, you can't. The Supreme Court says no. The Supreme Court is the final matter. Yeah. Can you provide me an example of a federal law that a president could be worried about breaking in their job as president? No, I can't. In a criminal way? Not really. No, I have a hard time envisioning that. I'm not sure. But I don't know. Maybe one will come up. Maybe I'll think about it more. That's why I don't know. I don't like it for a variety of reasons. But yeah, that's... Is there even evidence for elections being stolen or numbers being tampered with? Nothing that would be election determinative or outcome determinative in any state or district, I think, yeah. Do you think the fear was that due to separation of powers precedent, the Supreme Court didn't want to delegitimize the executive branch? I don't know. I feel like all I've heard over and over and over again is that the executive branch has way too much power, but... If Biden loses, can he just use this ruling to reelect himself using Trump's tactics? Seems like it. I don't know how you would get away from that. Joe Biden says that he thinks Joe Biden goes to have a conversation with the CIA director. It's not Ray right now, right? Who's the CIA director? Oh, William J. Burns. He goes to talk to Burns, and in that conversation, he tells Burns, listen, I think Trump is a threat to the U.S., or maybe not, I don't know, I just don't like him. We need to take him out. We need to assassinate him. So get some dudes, go get him. I don't know if he's at Mar-a-Lago or whatever. And yeah, report back. Let me know. That happens. Trump is assassinated. Biden's chilling at the White House. And the country is looking. And now every single Republican is obviously screeching and pissing and shitting and coming and diarrheaing. And their eyeballs are leaking out of their heads, all screaming on Twitter. What's going on? But then the Democrats calmly respond and they say, hey, if you don't like the fact that you think that Biden just assassinated your candidate, impeach him. That's literally all you can do. Impeach him and eat shit. Because you said that when the president of the United States is speaking with, the head of the CIA, that is exclusively within a core power of the president. You don't want to judicially review that action. That would be crazy. You don't want a president to have to worry about, serving in one of the most important roles, managing the protection and the defense of this country. Now, did Biden just order an assassination? I don't know. We can't review it judicially. That is a core and exclusive power. That's not given. Also, get familiar with these terms. Presumptive immunity is not granted there. Presumptive immunity happens when the presidential power has an overlap with the congressional power. A core exclusive presidential power is not given presumptive immunity. It's given absolute immunity. It's immune from subpoena, and it's immune from judicial review, meaning it can never be charged with a crime, and nothing about it can ever be used in any legal case ever. So if you don't like the fact that Biden ordered the assassination of Donald Trump while engaging in his core act as a president, then impeach him. That's it. And if he does it on the last day in office and you can't impeach him, then I don't know. That's it. That's the part that's so confusing me. Why would conservatives be excited about this? The same group that supposedly rigged the election is now essentially free to do whatever they want, and they're celebrating because they just assume Trump will win. That's a really good question. There are multiple ways to come at that. One is that most of them are just probably too retarded to know what this will result in or could result in. Two is that most of them are short-sighted, and they just see this as being able to exonerate Trump from his court cases, because I personally think that it's likely that the Mar-a-Lago case and the Jack Smith case will probably be completely tossed. I think Trump is now saved from both of those cases. I don't know about the Georgia one. I don't know how this is going to engage with the state investigation. I don't know how that works. So they're short-sighted, and they see it as being good because it exonerates Trump from his court cases, and then Yeah, and they just don't think Biden will do anything with it. I don't know. Yeah. They assume Trump will win and the Democrats will not abuse their power. Yeah, basically, yeah. How do you think Senate Republicans will respond, considering many voted against impeachment because they believe Trump could be held criminally responsible after leaving office? Bullshit. Don't ever believe anything Republicans say. Republicans have no fucking spine at all. Okay? Republicans are spineless fucking losers. Republicans, they're not even the SPD or whatever the fuck, the Social Democrats or whatever. I don't even know who they would just be, the Nazi party. Not to do the Voshian comparison. God, I wish I knew more. I wish I knew more about how this act came to be. But the Republicans will sit by and championing this as it happens the whole time. Like, that's it. That's all they've done the whole time. They haven't, like, stood in opposition to literally any of this. For me to truly understand the Enabling Act, I feel like I would need a better grasp on the core of German law. Fuck me. I don't always trust what I read on Wikipedia anymore. At least not for Israel-Palestine stuff. If this is just the text. When people typically say the government when they're talking about law, the government is separated from the parliament, right? Like the government is like the president and all that shit, and then the parliament is the other thing, I think. So what the Enabling Act did for Hitler was the Enabling Act gave Hitler the ability to pass laws, basically, which our executive doesn't have, and this ruling doesn't give him any de jure, meaning like as written ability to do that. Does it give him the ability de facto to change the way that he functions? Maybe. Arguably. Arguably. Do you honestly think that this could reach Nazi Germany levels just based on the last Supreme Court decision? No, I don't think that. It's never just one thing. It probably wasn't the case in Germany. It's probably not the case in any fascist. There's never just one thing that does it. Destiny, it doesn't empower him really. It just means he can't be charged, but his actions can still be checked. You're completely and totally fucking incorrect. The whole point of this ruling was that some actions have no checks. You're dead wrong. Damn, I got his attention for a second, but I typed my follow-up too slow. I may never know why Destiny consistently implies the Senate does not have the right to vote against a Supreme Court nomination. Oh, Holy 1T03. My bad. I didn't realize, or I forget sometimes, that I'm speaking to conservatives who are fucking retarded and don't know any of the history, any of the processes, or literally anything that they talk about. The issue with McConnell in his Senate and the lack of confirmation of Garland was not that the Senate voted him down, okay? That's not what happened. That wasn't the issue, all right? Go look it up. Go look up the process, do some reading, and educate yourself. That's not what the issue was, and that's not what happened. Let me grab a Red Bull 1 second. I don't think they can toss the Mar-a-Lago documents case because the document obstruction crimes were done after he was president. No. Well, the question would be if any of the initial stuff was even legally obtained. The thing is, the question is remember, the court defended the outer perimeter of what the president might consider like an official act. They defended the outer perimeter of what that could be, okay? So anything that could conceivably be an official act. So it is possible that him taking those documents, that him initially doing that maybe could conceivably be an official act. Maybe, I don't know. It depends on how far we run with. The thing is, like, everything is going to be argued from that for Trump's lawyers. They're gonna argue every single one of those things was an official act, and that he, at the very least, if not given absolute immunity, at the very least he's given presumptive immunity, and that needs to be overcome now in pretrial before. That needs to be declared, but I don't know. You would think that obstruction of justice after the fact probably shouldn't be, but who knows? We'll see. All these provisions you're citing, they're pretty similar to what was recently used during COVID in many European countries where executive bodies of state, government, or president could make some emergency decrees without consensus with the parliament. I don't know these things, but you're 99% you're wrong. I seriously doubt it. I'm pretty sure most countries, the United States included, gives executors of power pretty broad deference during times of like national emergency. But the idea that like, oh, well, during COVID, the president could have come to all of our houses and made all of us take our pants off and touch our butts in front of him and then recorded it and blah, like, fuck off. I hear that bullshit. Just to be perfectly clear, you guys all said that that was going to be the new normal indefinitely going forward, and that our whole future was destroyed and doomed because every fucking power that had been granted to was infinitely going to be abused in the future, blah, blah, blah. No, fuck you. Okay. Is there anything Americans can actually do about this ruling? Probably not. I mean, you keep voting for Democrats and hopefully don't have more Supreme Court justices that are conservative. What do you think about this flow chart with regards to the case? I need to go back to reading this. Pathways for prosecution after the Supreme Court. Types of conduct. You have official acts. Is it conclusive and preclusive? Core constitutional authority. So conclusive means I think it's definitely done by the president and it needs to be done by the president to run the country. And then preclusive means that only the president can do it and nobody else can. If the answer is yes, then you get absolute immunity for these actions, meaning no part of it can be questioned. No prosecution, no use as evidence, and you can't probe into it or do anything, right? Yeah. And the example given in the Supreme Court case was the pressure on... Oh, actually, it wasn't... That's just an example they're given. But them talking to the AG would have been, yeah. If it's a conclusive plus preclusive, core constitutional... If it's not, let's say there's overlap with Congress, does it pose any dangers of intrusion on the authority and functions of the executive branch? If the answer is yes, then you can't do anything. Boom. And then no, then maybe, yeah, then you can go down there, yeah. And then if it's unofficial conduct, then you can treat it as ordinary. But I don't know what's ever going to include unofficial conduct when you're the president of the United States, because almost everything can be argued to be official conduct. Will you react to Ben Shapiro on the ruling? Did he give a reaction to it? Please explain the difference between absolute versus presumptive immunity. I'm begging you, I don't get it. Okay, sure. Okay, limited understanding of the court system, so beware. Okay, in the United States of America, okay, you have a trial, okay? In order for there to be a trial, okay, a couple things have to happen first, okay? First, we're talking criminal trial, okay? First, there needs to be probable cause, and then from probable cause, we can get criminal charges, okay? So probable cause gets us criminal charges or an indictment, okay? And then one of these things is applied to a citizen who now is facing, charges or an indictment, okay? Now, before a trial date is set, okay, you've got pre-trial, where the defendant or the DA, I think, can file motions that can do a variety of things before the actual trial happens, okay? Now, there's a whole bunch of pretrial motions that I don't know about, okay? But you might file pretrial motions. I think a common one might be like a motion to dismiss. So you might file a motion to dismiss. You might say, hey, let's say, for instance, let's say that you've been indicted for a crime. And let's say that the indictment file says, yesterday we saw Stephen Bonnell and he was walking down the street and he looked at a woman. And when he looked at that woman felt, she felt like he sexually assaulted her with his look, okay? Now he's being criminally charged, okay? I would tell, my attorney would say, okay, well, hold on. My attorney's going to file a pretrial motion to dismiss, and he's going to say, hey, look at the criminal statute and look at what's laid out in the indictment. You would say, I think, prima facie, there's not actually a criminal case here. Even if the indictment is true, what's being alleged isn't even criminal conduct. My motion is that we should dismiss this case. Here you go. Now, I don't know if a judge can look at that and make a determination without the other side giving a counter motion, or if a motion just goes right to a judge. I think the motion is just gone to the judge and then the motion is considered by the judge. I don't think it has to be considered by the judge. The judge might be able to solicit information from the prosecutor. You've also got, like, both sides can be filing motions. There are cross motion filings where they file at each other, but you have all this stuff pre-trial, okay, where people are kind of like hammering out, like, okay, well, what exactly is it about? Can I dismiss this through some way? Do we add charge? Whatever. All this is pre-trial. Once all this happens, then the actual trial happens, okay? Assuming you get convicted, and then from there you get sentenced, okay? All right. What absolute immunity means that, let's say that I'm the executive of the United States and the Constitution says Stephen Bonnell, through exclusive power granted to the president, shall have the ability to look at any woman that he wants. That means that if I do anything within the purview of looking at a woman, even if I look at a woman and then I order somebody to murder her, okay? Let's say I'm looking at her, I say, God, somebody needs to kill her, okay? Let's do it, whatever. But I'm exercising the power of looking at the woman, okay? Because I'm exercising that core power, and that power is conclusive and preclusive. Because I have absolute immunity there, it is unquestionable, and you can't even bring charges against me. You can't even investigate that. You have no right to probe or do anything relating to that power, okay? You have to fuck completely off. It's beyond judicial review. Presumptive immunity means that in this court case, now I think this is a new legal thing that's basically been constructed in this court case. I don't think presumptive immunity is a thing that's ever shown up before, but presumptive immunity means that, let's say that I'm looking at this woman and let's say that I'm looking at this woman But let's say that let's say that Congress also has the ability to look at women. If you're a sitting congressman, you can also look at women, okay? Oh, cool, we've got the power too, okay? Let's say that as I'm looking at this woman, I look at her, I'm like, I'm gonna order a hit. Fuck this bitch, all right? Yeah, fuck her, okay? Because other people can do it. It's not exclusive and preclusive to me, okay? Somebody might look at that and they might go, okay, well, hold on. It is a power still to the president. So we're gonna presume that he's immune here. But if the state can argue that he wasn't acting in an official act, or if he was, that action, if that action wasn't, if probing this action wouldn't destroy the ability of the executive to do his job, if you can beat that argument in pre-trial, then and only then can we proceed to any sort of actual hearing, okay? So all of the presumptive immunity stuff, all of this is happening pre-trial. It's happening before anything actually goes to court, okay? This is presumptive immunity. You're presumed to be immune unless the prosecutor, in this case the state or the federal government, can put forth an argument for why you shouldn't have this particular immunity. Now, how you make that argument, I don't think the court has given any guidance on that. That's going to be for the lower courts to try to figure out. But so literally this, he can do this.
The people, my people are so smart. And you know what else they say about my people? The polls. They say, I have the most loyal people. Did you ever see that? Where I could stand in the middle of Fifth Avenue and shoot somebody and I wouldn't lose any voters, okay? It's like incredible. No, they say, Trump, we love you too, man. Trump's voters are by far, you know, I'm at 6.
Well, so this is the issue, is you don't know. The problem is, let's say Donald Trump is like, Donald Trump is walking down the street and he's like, well, I'm the commander in chief. I think that's an enemy, that's a militant, and I need to shoot him. I need to protect our country. Okay, well, he's the commander in chief of the military. It's a core function of the president, arguably one of the most important executive functions of the president. Should a court be allowed to review that decision? I don't know. Okay, let's read. So Thomas decides, I don't know why, but he's decided that he wants to say that there should never, ever, ever be a special counsel. That apparently there should never be special counsels, and they all need to go because they're not constitutional. I don't know why. I have no idea why that's taken up here, or why Thomas decided to opine on this in this ruling. I don't know, but he's decided to write his manifesto here on it. Jesus Christ. Okay. Thomas regularly uses his concurrences on things he hates. Bayzed. Oh, we didn't finish watching this either. Sorry, I'll do this real quick. I keep coming back to the fact that the court gives no test for overcoming presumptive immunity. In Nixon v. Fitzgerald, it was a balancing act, public interest versus intrusion into the executive.
I understand they're not being permitted in.
Biden should just order all lower courts to ignore the Supreme Court's rulings. He could do that as an official act, no? No. Trump, no. The courts don't exist. Biden has nothing to do with the courts. The courts exist under the judicial. The only power that the president has for the courts is appointment. He can appoint judges, but he can't tell them how to judge. That's part of the judicial.
The problem, you can contact the governor's office, the Speaker of the House, the Senate Majority Leader, or...
Now, could the President of the United States talk to the Attorney General and tell the AG, hey, tell all the judges don't enforce this? Sure, that's a core power of the President of the United States, and he should be granted absolute... In fact, he's already been granted absolute authority with essentially every single conceivable question or every single conceivable thing he could have a discussion with his Attorney General with about the operation of that branch.
The governor's press release this morning was said due to COVID. Is that the reason being given?
No.
All right, that was what the press release said. Is there another reason why?
You'd have to ask the governor's office to answer that question. I don't have
We
any
have a
knowledge.
copy of paperwork that was prepared as electors under their constitutional duty. Can I speak to the Sergeant of Arms of the Senate to deliver it to the chamber today?
He's in a meeting right now with the Electoral College. He's not available to meet with us.
Captain Green, is it Captain?
First Lieutenant Green?
First Lieutenant, can you deliver this?
I cannot.
Okay. Is there anyone here?
Did the authentic electors / state government know what they were trying to do? I don't know if they knew of this in advance. I'm not sure.
That's willing to allow us.
Well, actually, we just watched. I think what's the name of the lady? Maddow, I think on MSNBC. I guess in her program, I was only reading the titles and listening a little bit. It sounded like she was trying to make the argument that some of the paperwork that these fake electors had looked like it was copied from the paperwork from the official delegates. So it seems like somebody on the inside might have been working with them. Maybe. Now, that sounded like that was all the evidence. I don't know if they had more than that, but...
Elected officials and electors to deliver this to the Senate today.
The DOJ does not employ judges. They are a separate branch. Oh, yeah. I'm sorry, that's true. The federal government can only appoint judges. Even the attorney general, nobody gives instruction to the judiciary. That's true. I'm sorry, that was completely wrong. No part of the. I'm sorry. There's an easy test for that too. If you understand how government functions, if the president doesn't have control over something, then nobody beneath the president has control over something because the president is the executive branch, and everything that exists underneath the president only exists at the essentially to help the president do his job. That's it. In an ideal world, the president would be a super machine that doesn't need any of these lower things. So if the president can't do it, then nobody beneath him can do it because they all exist underneath him.
Today at 2 p.m.
Okay. I can ask the Senate Majority Leader, the House Majority Leader, and
Senator Mike Shirkey, would you deliver that to him? Tell him Ian Norton.
You can contact his office directly and make arrangements to drop that off to him, sir. I'm not going to take anything.
You're not letting us in the building. His office is inside.
He's not here.
What's that?
He's not here.
So are you telling me that the Senate chamber is in session and the Senate leader's not here?
Yeah. So you'd have to contact his office and make arrangements to meet with him to turn over.
Somebody from the governor's team that's running this.
You'd have to contact the governor's office with their team to make arrangements for them.
Is the president a cop? I believe that the president would have. Wait, that's actually a really interesting question. Hold on. Can the president of the United States arrest someone for a federal crime? Could he theoretically? He must be able to, right? Politics Stack Exchange. Can the president personally arrest someone? If all executive powers held by the president can arrest, doesn't that mean the president can too? Everyone can make an arrest, but I suppose you're not asking about that, are you now? In the UK, any citizen can perform an arrest, however, in the case of citizen, no one cares. Any individual in the U.S. No, cringe. The power to make an arrest is vested in certain official positions. These positions are established by federal, state, or local statute, i.e. by Congress, state legislatures, or local committees. An individual is supposed to granted the power when they take these offices for the term they hold such offices. Under normal institutional constraint, that's not a, I don't know if that's a legal question. Man, I'm so confused, or I'm so curious about this. Can the president personally arrest someone? Reddit. Huh. Before 2023. I think that, so in any office that exists under the president has to be created by Congress. It might be the case that if the president is authorized by Congress to create an office to enforce a law, I don't know if that means that he personally can enforce it. I'm not sure. A scene in the TV show Designated Survivor shows the president arresting a state governor for treason. What? President arrest.
President Kirkman, Governor Royce.
Welcome to Washington, D.C.
Thank you. Took some doing, but I had a very nice conversation with your special advisor, and I welcome this chance for an honest and open dialogue.
Well, I think you'll find that I'm not going to be very flexible on this. You see, I believe that all Americans, regardless of race or religion, should be afforded and protected by the same inalienable rights.
If I may.
You may not. Governor, you violated the rights of the citizens of Michigan, and today you conspired with the National Guard to defy a direct order from the president. James Royce, I am placing you under arrest for treason against the United States of America. Marshals.
Reasonable.
Could he do that? Could he arrest him himself? Well, now, with Kiefer Sutherland as the source, it seems like maybe the president can. Powers of Federal Bureau of Investigation. The director, associate director, assistant to the director, assistant director, inspectors, and agents of the Federal Bureau of Investigation of the Department of Justice may carry firearms, serve warrants and subpoenas issued under the authority of the United States, and make arrests without warrant for any offense against the United States committed in their presence, or for any felony cognizable under the laws of the United States, if they have reasonable grounds to believe that the person to be arrested has committed or is committing such felony. Okay. Can Congress grant powers to a federal office but not the president? Could you do that? There's no way that's possible, right? Because couldn't you theoretically, no, hold on, this can't be possible. Because couldn't you theoretically have Congress create like a mini executive who's stronger than the president, like, and start granting him a bunch of powers that the president doesn't have? This is probably in the actual Constitution itself, huh? Off topic, but is it true that black guys on average have bigger ding-dongs, or is that just a myth? My personal opinion is I think all penis-length research is, like, highly not reliable. I've seen so many fucking random like, things on... average dick sizes between, like, there are some fucking, what was that one study that was saying like the average dick size of some African countries like 9 inches long? No shot. I don't know if I trust any of that research. By vesting Congress with all legislative powers, Supreme Court has viewed the legislative vesting clause as limiting the authority Congress can delegate to other branches of government or private entities. In general, the court has held that the legislative power of Congress cannot be delegated. Okay. Okay, enough of this. One video and then we read. We're wasting time. What is this? Today in Lugano. Is somebody about to die in this video? No, it's Europe. Wait, why do they have their guns out if they're not going to use them? Or are they stun guns? Are they tasers? Or what is... Why would you hand-to-hand fight a dude when you have a gun out? Or in Europe, do you guys have like gentlemen's agreements to just not shoot each other? Sounds like a real gun.
Ma dov'è che là? Quanti ce ne sono lì? Ma Dio cane.
Okay.
Have conceded here the last time that you and I spoke in April, and John Sauer, who was arguing this before the Supreme Court, that some of what's alleged would be considered a private act. So that would mean that at least part of this case from Jack Smith would go to court based on what you have said before, right?
We've admitted consistently that there are acts alleged in the indictment that would constitute private conduct, but we believe that if the official conduct, the immune acts in the indictment are stripped away, that Jack Smith doesn't have a case, that this case should be dismissed on that basis.
Possibly, that might be true.
I don't think there's sufficient private conduct here to support the indictment, to support the ongoing prosecution, and that's what we're going to be litigating in front of the district court now.
Even just the false slates of electors, you don't think that would constitute enough for a trial?
Well, we would say alternate slates of electors, and as we argued before the Supreme Court, alternate slates of electors have been a method used by previous presidents, most notably Ulysses S. Grant, to ensure the integrity of prior elections. So we believe the assembly of those alternate slates of electors was an official act of the presidency. That's what we argued before the Supreme Court. The Supreme Court has reserved that issue for determination by the district court, and we'll see how arguments fall in front of the district court.
Yeah, we've walked through those historical references here before. None of them compare to what we saw in 2020 with the fake slates of electors. But Will Scharf, great to have your reaction to this. Thank you for joining us tonight.
I would disagree with that, Caitlin, but great to be with you. Thank you.
He would be factually incorrect, but... How could you possibly argue for that? You can't. You're relying on the other person to not have an understanding of what those prior electoral acts, what those prior electoral slates were authorized for. Glenn Greenwald tried that when we debated. He tried to float that. Well, they've done this before, but then as soon as I pushed on it, hold on, why did they do that in Hawaii? He was like, okay, yeah, well, it was a close election, and the state actually authorized it. It wasn't just a secret private group of electors. The state authorized it because they were doing a recount, and the recount was incredibly close, so that way they would authorize either set depending on who won. It's a totally different circumstance. It's actual fucking bullshit. Yeah, the only way that argument works is if the other person is just not familiar with the history.
The Republicans more powerful. Right, but again, so that plays into the idea that anybody but Trump. And what I'm saying is that I would rather have Trump be president for 4 years and build a real left-wing movement that can get us what we deserve as a people than to let Hillary be president and we stay locked in the same space.
Yeah, where is that left-wing movement at right now, by the way? Where are they at?
Would rather not have Donald Trump be president at all, period.
man.
I just felt
Independence.
How many years ago was this? He said this 4 years ago, didn't he? Or 8 years ago? This you. No, I didn't say I'd rather Trump be president. That's a ridiculous misrepresentation of what I said. You're excluding the fact that I also said that we should do everything we can to keep Trump out of the White House. You're also ignoring the fact now that my concern about... no, I didn't. I'd rather Trump be president. You literally said it and it's on video too.
Again, the electors by statute, it's statute MCL 168.47, have to be at the Senate chamber 2 days.
Okay.
At 2 p.m. They're trying.
I'm telling you that they're not going to be allowed to enter the Capitol, sir.
All right, thank you, Lieutenant.
You're welcome. Thank you.
The electors can speak for themselves, but the hope and plan is for them to follow their constitutional duty. Under the U.S. Constitution, not just the Michigan Constitution, but under the U.S. Constitution, the electors have a duty to vote for their chosen candidate. In this case, the GOP electors slate their chosen candidate, President Trump. The Democrat electors are inside, I'm told, slating their chosen candidate, Joseph Biden. There's actually Green Party and Libertarian Party electors selected before the election as well. So the statute says it has to be done at 2 p.m. That's why they're here trying to do it. That paperwork is signed, it's sealed, and it's trying to be delivered. Stevie Wonder and Motown, I think, said that a little better than I did. But the point is that's not being happened. They're being stopped from fulfilling their constitutional duty. Now, I would call upon the Michigan legislature in the People's House. This is the legislature building in the People's House to finish their investigation so that we know which set of electors should ultimately be chosen before.
Did any of these fake electors get in legal trouble with this? I think in most of the states, yes. Most of these people are now being prosecuted for, I would imagine, for perjury. I don't know what else. Can you make sense of what he said? He's citing the laws correctly. He's just lying about them being the slate of electors. The slate of electors are supposed to meet. They're supposed to transmit their votes to Congress and to NARA, but these guys are not them. These guys are just private citizens that are falsely perjuring. They're alleging that they are the electors, but they're not. They're just lying under direction from Donald Trump.
A rash decision is made, especially while that investigation is ongoing, especially why a judge up in Antrim County, Judge Elsenheimer,
Abba said, at the time, nobody knew how bad Trump would be. Not the craziest thing to say. If he feels differently now, perfectly justified. No, it's not perfectly justified. He is, how old is he? 45 years old. He knows how the Supreme Court works. The strongest argument in favor of Hillary Clinton was always the Supreme Court. Everybody knew it at all points in time. And arguably, the most destruction that Trump has caused has been to the Supreme Court, to where Roe v. Wade went. And Chevron, a lot of people have been talking about, and now this decision. So, no, nothing has changed significantly. Everybody knew, no matter how bad Trump would be, that he would nominate very conservative justices. That was always known.
Just this morning, released a previously sealed or previously proprietary report, a forensic report that shows the voting machines used in Antrim County and in several other important counties throughout the state showed an error rate above 60% on the tabulation of the counting of votes. Under Michigan law and under federal law, under the Help America's Vote Act, that error rate is supposed to be less than 0.2%. But in Antrim County, based on those machines, the error rate was over 60%. And it would kick it into a adjudication by software, by code. It would kick it into an adjudication where the error rate was over 80%. That affected the race up in Antrim County. It was called user error and human error. That wasn't the case at all. That report released this morning over.
Would you say there wasn't ever liberal hysteria and they were 100% right about Trump in every way? The problem is that the challenge when dealing with Trump, there's multiple challenges at play here. One is that conservatives have completely flown off from reality. So the conservatives are a huge part. The second problem are uninformed people in the middle that just don't know any better. And then they always accuse the left of overreacting. And the third part was legitimately Trump was way worse than anybody thought any reasonable person thought he would be. Maybe. I consider myself a reasonable person. I thought that Trump getting elected would be pretty bad. But then I also thought that, like, it's probably just going to be business as usual. Like, whatever. It's bad, like, it happens. Bad presidents come and go, whatever the fuck. I don't think any, like, intelligent person actually thought that he would be this unhinged. But then a fourth issue is that Donald Trump does so many unhinged things that it's hard to make him account for those things, because when you start to call out too many, all of the Trump fans just go, Trump derangement syndrome, Trump derangement syndrome, Trump derangement syndrome. Uninformed people in the middle will look at it and go, yeah, true, these guys are being deranged. Like, you guys are being way too harsh on Trump. You guys are being not fair. And so when you're on the sidelines, you're kind of stuck in this weird world. It's like, okay, well, I can't criticize Donald Trump for everything he does because that makes me seem unhinged. Meanwhile, conservatives run pieces about Obama preferring Dijon mustard to ordinary mustard or wearing tan suits. Okay, well, we have to be careful about criminal investigations into Donald Trump stuff, even though the Republicans have been obsessing about Hillary's emails for years. Okay. We can't focus. We just have to, I guess, completely drop the idea that Donald Trump won't publish his taxes, won't divest from his businesses, is a billionaire with assets all over the world, and is also president of the United States making decisions. But we have to talk about Hunter Biden being on the board of Burisma, I guess. Like, the problem is that, like, if you're in a Democrat world, the Republicans have such an unbelievably low standard of what they tolerate and as soon as you try to hold them to account for anything, they try to play by your rules. They try to play with the Democratic rules. Like, well, hold on. I thought that we weren't supposed to criticize for that. So, yeah. So there's two huge sets of rules. And Ben Shapiro admitted it when he debated me. There's two different sets of rules. When the Democrats are defending their people and when they are attacking the Republicans, they have to play by the Democrat rules. When the Republicans are defending their guy or attacking Democrats, they get to play by the Republican rules. So you end up, it's an unwinnable world. You can't win in that world because what's greenlit for Republican conduct is so unbelievably wide, and what's available for criticism is so narrow that it's an unwinnable. Yeah. But what are you going to do? What's the solution then? I don't know. We're get rid of the internet. I think the internet's kind of fucked a lot of us, but I guess you just keep making. I mean, like, technically, Democrats are doing better and better. We just don't see it as much because the institutional power, or I shouldn't say the structural power. For as much as conservatives hate institutions, the structural power of the government broadly supports Republican legislative and presidential power because the Senate gives undue weight to red voters, the House gives undue weight to red voters, and the Electoral College gives undue weight to red voters. And now the Supreme Court favors red voters. So technically, because the Republicans benefit so much from their structural power, it's hard to see when Democrats are making gains. But I mean, like, even if you consider, like, people, screech and moan about, like, oh, Hillary Clinton got destroyed by Donald Trump. Well, no, she didn't. Hillary Clinton annihilated Donald. In fact, I don't think I've heard a stat on this, but it wouldn't surprise me if Hillary had. No, that can't be true. Never mind. No, that wouldn't be true. Besides Barack Obama, I bet Hillary Clinton probably had some of the most votes. Like, the popular vote between Hillary Clinton and Donald Trump there's a huge gulf between this. 3 million votes. It's over a 2-point difference in votes for Hillary versus Trump. But again, because of the structure of how the United States government works, Donald Trump won by almost 80 electoral votes. So it's hard to see if Democrats are gaining because of the structural power that Republicans have. Wait, why the House isn't it proportional? The House tries to be proportional, but it still favors small states pretty significantly. Even the House is. One thing that I would support immediately is I think the House of Representatives should be expanded. Absolutely. The House of Representatives should be way more representative of people rather than land, because that's what the Senate is for. There's no excuse for the House to not accurately resemble the constituents of the United States. Hillary was so unlikable, though, no one trusted her. Apparently 3 million more Americans trusted Hillary than Donald Trump, but how does the House favor small states? Because it's not directly proportional. Like, I don't know what the exact numbers are. I'm sure you look them up, but it would be like this. Let's say that you have a state with 1 million voters, and let's say that you have a state with 10 million voters. The way that it works right now in the House of Representatives is it would be like, oh, the 10 million voter state, that state has 10 representatives. The 1 million voter state, they only have 3 representatives, right? So conservatives in chat, I'm sure they've been saying this when I've been reading these two. Conservatives might say some shit like, oh, no, actually, larger states have more representation in the House. No, not really. Like the state kind of does a little bit, but like per voter, you still have less representation, even in the House of Representatives. And I don't think it should be that way. The Senate already has 2 votes per state. There's no reason to favor land in the House as well. This should be rebalanced. Even in the House of Representatives, the smaller states are disproportionately represented.
The objections of the Attorney General's office and over the objections of the Secretary of State's office, they tried to prevent that report from being released. They tried to keep that concealed from the people of Michigan.
You're thinking of Electoral College. Wyoming only gets 1 House vote. The I don't. Why are you arguing with me on this? Okay. House. What would I even look up to? What would I even look up to see this? Vote, individual vote weight per citizen, House Representatives. Crescential, come please, come. Crescential, as an attorney, watching Destiny go through these Supreme Court cases and legal issues makes me doubt his research in other areas. Please come to the disagreement room. Nothing makes me happier. Attorneys are the highest level of hubris to level of education, okay? You have one of the most dipshittably attainable master's degrees. All you have to do is read and pass a test, okay, that like fucking 80% of people fucking pass anyways, all right? Nobody gives a fuck. And then you go and you practice, and then you forget literally every fucking thing you've learned in school anyways, and most of you suck shit at your jobs regardless, okay? Come in and chat. Come in and argue if you want. If you think that any of my analysis has been incorrect, feel free to jump into the Stream Disagreements channel on Discord. Go for it, please. Yes. Nothing makes me feel smarter than chewing up, okay, the worst type of grad student. Please come in and chat. How do we know that Republicans are the crazy ones and not us? They seem to have the exact same condition. We just look at the facts. I don't know. Give me one to argue with, and I'll show you. The U.S. population keeps growing, but the House of Representatives is the same size as in the Taft era. Wide range of representation ratios across the state. So these are the number of people represented by one lawmaker. So if you go to smaller states here, you'll see the number of people represented by one lawmaker is 600 to 700,000. If you go to an ordinary state, it's 700 to 800,000. And then for some states, I guess you got super fucked, and you've got like 800 to 900,000 people represented by one lawmaker. Wait, so you brought up Wyoming was your example. How many representatives does Wyoming have? Seven states have one representative: Alaska, Wyoming, Montana. Oh, sorry, you said one. So Wyoming population is 581,000. California has 52 representatives. California population. So 300 or 39, 1, 2, 3, 1, 2, 3 divided by 52. So if you're in California, you get 750,000 people get one representative. In Wyoming, it only takes 580,000 people to get one representative. This is what I mean when I say the House isn't balanced either. In a perfectly balanced House, California would have more representatives, right? Destiny, that is wrong. What's wrong? What did I just say that's possibly wrong? Is it true that undocumenteds are considered part of the population for House rep calculations? I believe that is true, but because of the way the House is balanced right now, the last poll that I think it was a Gallup or Pew, I think that conservatives are the ones that benefit from that undocumented population by one vote right now, I think. Pew, let me check on that. Pew Research, census, illegal immigrant House seats. Was it just for Electoral College seats or was it House of Representative seats? I don't remember. Oh, it might be this? What did I see here? How removing unauthorized immigrants from the census statistics could affect the House reapportionment. So if you were to reapportion the House and you were to get rid of illegal immigrants, Texas and Florida would both lose 1 seat. Alabama, Minnesota, and Ohio would gain 1 seat, and California would lose 1 seat. Conservatives will screech about how illegal immigrants are helping give Democrats votes, but it's not true. It doesn't, yeah. I think we should get rid of winner-take-all electoral points for presidential elections. Me too. I think it's real dumb, but... Okay. Oh, sorry. 30 seconds left on this yapper.
They tried to keep that concealed from the people of Michigan. Your name? My name is Ian Northon. IANNORTHON. I'm a private attorney. I'm representing a charity called the Amistad Project. It's a 501c3, and it's affiliated with another charity called the Thomas More Society out of Chicago. We filed several pre-election lawsuits on election integrity. Every elected official, including the legislators and including everyone else here, the governor and everyone else, has a constitutional duty to ensure the accuracy and integrity of the election. And that's what these electors were trying to do here today.
Okay. Thomas is decided to write an anti-special counsel manifesto in this opinion, and so we were reading through that. Oh, thankfully, it's not that long. Where were we? Regardless, this provision would be a curious place for Congress to hide the creation of an office for a special counsel. It is placed in a chapter concerning the Federal Bureau of Investigation, not the separate chapters concerning the U.S. attorneys or the now lapsed independent counsel. To be sure, the court gave passing reference to the cited statutes as supporting the appointment of the special prosecutor in United States v. Nixon, but it provided no analysis of those provisions' text. Perhaps there is an answer for why these statutes create an office for the special counsel. But before this consequential prosecution proceeds, we should at least provide a fulsome explanation of why that is so. Even if the special counsel has a valid office, questions remain as to whether the Attorney General filled that office in compliance with the Appointments Clause. For example, it must be determined whether the special counsel is a principal or inferior officer. If the former, his appointment is invalid because the special counsel was not nominated by the President and confirmed by the Senate, as principal officers must be. Even if he is an inferior officer, the Attorney General could appoint him without presidential nomination and senatorial confirmation only if Congress by law vested the appointment in the Attorney General as a head of department. So the special counsel's appointment is invalid unless a statute created the special counsel's office and gave the Attorney General the power to fill it by law. Whether the special counsel's office was established by law is not a trifling technicality. If Congress has not reached a consensus that a particular office should exist, the executive lacks the power to unilaterally create and then fill that office. Given that the special counsel purports to wield the executive branch's power to prosecute, the consequences are weighty. Our Constitution's separation of powers, including its separation of the powers to create and fill offices, is the absolute central guarantee of a just government and the liberty that it secures for us all. There is no prosecution that can justify imperiling it. Let's do this. Okay. Chief Justice Roberts writing the majority opinion. That was this. Then we have Clarence Thomas concurring, argues there is no ability for the special counsel to exist. In this case, there has been much discussion about ensuring that a president is not above the law. But, as the court explains, the president's immunity from prosecution for his official acts is the law. The Constitution provides for an energetic executive because such an executive is essential to the security of liberty. Respecting the protections that the Constitution provides for the office of the presidency secures liberty. In that same vein, the Constitution also secures liberty by separating the powers to create and fill offices, and there are serious questions whether the Attorney General has violated that structure by creating an office of the special counsel that has not been established by law. Those questions must be answered before this prosecution can proceed. We must respect the Constitution's separation of powers in all its forms, else we risk rendering its protection of liberty a parchment guarantee. So when he does this, writing here, is he asking somebody else, can somebody else please challenge this in court so that I can strike it down? Or what is the okay, I don't know why I'm asking you fucking losers. Fuck you guys. Then we have Justice Barrett concurring in part. Destiny, are either of these potentially criminal or both immune from judicial review. Jackson implementing the Trail of Tears legislative act, or Roosevelt putting the Japanese in internment camps executive order. I don't know enough about the details of either of those to give you an accurate assessment. Okay, Thomas was a full concurring. Okay. Okay. What is Roberts' first name? Justice Roberts. Jane, really? Wow. I was unaware. It's John Roberts. Okay. And then it's Amy Coney Barrett, right? No, Coney. Amy Coney Barrett. Amy Coney Barrett, concurring in part. Okay, we'll see what she says. For some reason, she was supposed to be the most unhinged of the new conservative appointments. I feel like most of the stuff she's written has been pretty fair, but we'll see what she says here. For reasons so concurring in part means that she is voting to, she's voting with the majority. She's concurring, meaning that whatever the ultimate question was that was to be determined by the court, she is agreeing with that. She's giving it an upvote. But when she says concurring in part, that means that there should be a substantive part of the majority ruling that she disagrees with, even though she still supports in totality the decision. For reasons I explained below, I do not join Part 3C of the court's opinion. Okay. Court 3C. Do I need to go back and look at this, or is she going to talk about what that was? Let's just go check it real quick. Fuck me. Oh, 3C. Oh, A, B, C. And then 4? Is this right? Was this 3C? I don't know which C this is. That's 4. Okay. 3C. The essence of immunity is its possessor's entitlement not to have to answer for his conduct in court. Presidents, therefore, cannot be indicted based on conduct for which they are immune from prosecution. Indicted based on conduct for which they are immune from prosecution. Oh, this has to do with considering evidence from immune acts as well, that you can't even use them as evidence for other crimes. So she's going to disagree with that part. Interesting. Okay. So she dissents in part, but her view still counts as full approval for the ruling? No. I don't think you can... Wait, can you dissent in part? I think you just concur in part. And then if you dissent, you dissent. That means you disagree with the ruling. Can you dissent in part? I think you can only concur in part, right? Or you just dissent, I think. But who knows? Google it. The remainder of the opinion is consistent with my view that the Constitution prohibits Congress from criminalizing a president's exercise of core Article II powers and closely related conduct. That said, I would have framed the underlying legal issues differently. The court describes the president's constitutional protection from certain prosecutions as an immunity. As I see it, that term is shorthanded for two propositions. The president can challenge the constitutionality of a criminal statute as applied to official acts alleged in the indictment, and he can obtain interlocutory review of the trial court's ruling. Let's see. The president can challenge the constitutionality of a criminal statute as applied to official acts alleged in the indictment, and he can obtain interlocutory review of the trial court's ruling. Interlocutory review. I don't know what that means. Interlocutory review. The term interlocutory is used to indicate a lack of finality. An interlocutory appeal is an appeal to a non-final order issued during the course of litigation. The collateral order doctrine sets forth the rules for such appeals. Interlocutory appeals are extremely rare, and a three-part test determines whether the collateral order exception to res judicata makes such an appeal possible. Res judicata, am I pronouncing this right? Why doesn't it ever give me pronunciation?
We are looking in, so make sure to stay down saying the first word in English, res or raise. So res judicata or
Res judicata.
Res judicata.
Res judicata. Okay. A three-part test determines whether the collateral order exception to res judicata makes such an appeal possible. 1, the order must have conclusively determined the disputed question. The order must resolve an issue completely separate from the merits of the action. The order must be effectively unreviewable on appeal from a final judgment. Is there like a... Legal U.
Sometimes rulings need to be addressed before the end of the game. In football, we call this an instant replay. When a ruling is challenged before the trial court enters an appealable judgment, this is called an interlocutory appeal. Interlocutory is a fancy legal word which comes from a Latin word for to speak between. An interlocutory appeal is when a ruling is reviewed by an appellate court before all claims are resolved for all parties involved.
Oh, interesting. So basically does this mean that like in the middle of a trial, or would this still be a pre-trial thing? Or could it be in either? So you're basically appealing a part of a case before the case is even done. Okay.
Typically, before an order is appealable, the case must be finalized in what is called, well, a final order. But when an order doesn't decide the whole case, it's called a non-final order. A non-final order can only be appealed in accordance with certain rules. The following types of non-final orders are eligible for immediate appeal. Orders that rule on venue, injunctions, personal jurisdiction, the right to immediate possession of property, class certification, arbitration entitlement, workers' comp immunity, and qualified immunity. Also, in family law matters, immediate monetary relief or child custody. But there are times when an order doesn't qualify as one of these non-final appealable orders, but still needs immediate review by the appellate court. Generally, these involve immediate harm that can't be prevented or fixed by a normal appeal after a judgment has been entered. In these situations, you may be able to get an appellate court to look at the ruling using what is called an extraordinary writ. As you might guess, writ is just an ancient way of saying written. It just means a written court order to act or abstain from acting in some way. The most important ones, for civil litigation anyway, are writ of certiorari, writ of prohibition, and a writ of mandamus. Certiorari is Latin meaning to be informed of. Writ of certiorari, besides being difficult to say, is the jack of all trades writ.
I think this is generally the one that when people are writing to the Supreme Court, like you see this in all of our Supreme Court decisions we have to review, these are writs of certioraries.
Its role and scope may vary depending on what court you are in, but it functions as a safety net. It's there to halt a miscarriage of justice when no other remedy exists. A writ of prohibition is when a higher court orders a lower court to cease litigation because it lacks jurisdiction. And a writ of mandamus, which is an order from a higher court to a lower court or public official, forcing them to do something that they are already required by law to do. Appealing, whether interlocutory or otherwise, is something that requires the right kind of moves. The legal you kind. Legal you, where you are your own best lawyer.
What a horrible idea. Don't do it. Okay. Wow, call me Mar100. Thanks for gifting 10 memberships in YouTube chat. Okay, so the president can challenge the constitutionality of a criminal statute as applied to official acts alleged in the indictment. And then he can obtain interlocutory review of the trial court's ruling. So Amy is basically saying, or I'm sorry, I should say, Justice Barrett is saying here that the president is allowed to challenge the constitutionality of a criminal statute by saying that, like, well, this wouldn't apply here by way of the Constitution to this particular act, and I can interrupt a court ruling, or I can do this in pretrial to say that, like, we're never even going to court over this, basically. So she's saying this here, okay. There appears to be substantial agreement on the first point. Like the court, the dissenting justices and the special counsel all accept that some prosecutions of a president's official conduct may be unconstitutional. I think we can all agree with that, right? I think that's fair. See post at 16, brief. As for interlocutory review, our precedent recognizes that resolving certain legal issues before trial is necessary to safeguard important constitutional interests. And then here, I think we can all agree on that as well. For instance, I probably shouldn't be able to sue, the president for some essential, I shouldn't be able to sue the president and say, I don't think you actually should have classified this nuclear secret. Let's go to court and argue about it and have everybody look and see. And then you argue about it and blah, blah, blah. And it's like after the whole thing, you're like, okay, you're right. We never, or actually you lose, you're wrong. Despite the fact that we just gave you discovery and a jury of normal citizens saw it, this nuclear secret actually really did need to be completely secret. But since we went to court, it kind of doesn't matter now. Everybody that was part of the process knows, right? So there are definitely, Justice Barrett is fair here when she says that some questions should never be asked of the president, right? You should probably never be able to criminally indict a president as like the commander-in-chief, or maybe in highly exceptional cases, maybe. And also that some criminal questions that might be asked of the president, some criminal matters, probably should just never go to court. But there should be some ways that we could block this before it's decided in court. I think all of us, every reasonable person, I think, should be able to say there's at least strong arguments to favor that, right? Properly conceived, the president's constitutional protection from prosecution is narrow. Oh, fuck. Am I about to be a huge Justice Barrett simp? I read her concurrence in the, in that Section 14, or the 14th Amendment Section 3 case, and I thought her concurrence, was very fair. But she's concurring with the decision still. Why would she concur? It's a 6-3 decision anyway. Are judges allowed to confer with each other before they finalize it? Like, why not 5-4 it? Because she doesn't want to show division in the conservative part of the court. That shouldn't matter. Because she still does concur. Because they don't know their decisions. I don't know. We'll see. Properly conceived, the president's constitutional protection from prosecution is narrow. Like, I hope that what she addresses in the rest of her concurrence is, listen, guys, I agree, broadly speaking. No, I agree conceptually with what the court is saying. But the problem is that they've opened with this presumptive immunity, and even with some of their absolute immunity, they've opened the question on how much presidential power is unquestionable and can't even be criminally reviewed. That's crazy. That's what I hope. That's what I hope she says. But let's see. Okay. The court leaves open the possibility that the Constitution forbids prosecuting the president for any official conduct, instructing the lower courts to address that question in the first instance. See ante at 14. I would have answered it now. Though I agree that a president cannot be held criminally liable for conduct within his conclusive and preclusive authority and closely related acts, the Constitution does not vest every exercise of executive power in the president's sole discretion. Congress has concurrent authority over many government functions, and it may sometimes use that authority to regulate the president's official conduct, including by criminal statute. Article 2 poses no barrier to prosecution in such cases. So Amy's bringing up something here that Roberts already said. He said, sure, there is overlap. That's why we would call it presumptive immunity. But she's also saying that there is no separation of power issues. There's no separation of powers issue by having Congress regulate the president's official conduct, including by criminal statute. I would thus assess the validity of criminal charges predicated on most official acts, i.e., those falling outside of the president's core executive power, in 2 steps. The first question is whether the relevant criminal statute reaches the president's official conduct. Not every broadly worded statute does. For example, Criminal Statute 956 covers conspiracy to murder in a foreign country and does not expressly exclude the president's decision to, say, order a hostage rescue mission abroad. 18 U.S.C. 956, subsection A, the underlying murder statute, however, covers only unlawful killings. Section 1111 or whatever, the Office of Legal Counsel has interpreted that phrase to reflect a public authority exception for official acts involving the military and law enforcement. Memorandum from blah, blah, blah. Okay. We'll read her footnotes because she's not fucking retarded like Roberts. Consistent with our separation of powers precedent, I agree with the court that the supervision and removal of appointed high-ranking Justice Department officials falls within the president's core executive power. I do not understand the court to hold that all exercises of the take care power fall within the core executive power. I agree with the dissent that the Constitution does not justify such an expansive view. Okay. Okay. And she even brings up against Sheikh Anwar al-Awlaki. That's the case that she's citing. Oh, it was when the Office of Legal Counsel was giving their opinion on the legality of that. The thing she's citing to is applicability of federal criminal laws and the Constitution to contemplate illegal operations against Sheikh Anwar al-Awlaki. I express no view about the merits of that interpretation, but it shows that the threshold question of statutory interpretation is a non-trivial step. That's a good point, because Roberts said, you want us to allow unconstitutional things and leave it to the discretion of the judiciary? I'm sorry, sir. Here's a quote from an irrelevant court case. We would never trust the judiciary with non-constitutional things on the books, right? And Amy is countering. She's saying, well, actually, the statutory interpretation is not just anything. Like, there is valid ways to do these types of interpretations that also still conserve the core functioning of the president without requiring such broad immunity. If the statute covers the alleged official conduct, the prosecution may proceed only if applying it in the circumstances poses. Is this a typo? Should that be if? If the statute covers the alleged official conduct, the prosecution may proceed only if applying it if the circumstances poses no danger of intrusion on the authority and function of the executive branch. On remand, the lower courts will have to apply that standard to various allegations involving the president's official conduct. Some of those allegations raise unsettled questions about the scope of Article II power, but others do not. For example, the indictment alleges that the president asked the Arizona House Speaker to call the legislature into session to hold a hearing about election fraud claims. Let's read her footnote here I should read the footnotes as they come up, I'm sorry. This analysis is unnecessary for Okay, hold on. She's talking about, on remand, the lower courts will have to apply that standard to various allegations involving the president's official conduct. This analysis is unnecessary for allegations involving the president's private conduct because the Constitution offers no protection from prosecution of acts taken in a private capacity. Sorting private from official conduct sometimes will be difficult, but not always. Take the president's alleged attempt to organize alternate slates of electors. In my view, that conduct is private and therefore not entitled to protection. So she's taking a very narrow view of what she would consider official conduct, although it feels like Roberts is taking a highly expansive view of what he considers official conduct. The Constitution vests power to appoint presidential electors in the states, and while Congress has a limited role in that process, the president has none. In short, a president has no legal authority and thus no official capacity to influence how the states appoint their electors. I see no plausible argument for barring prosecution of that alleged conduct. I wish that, you know what is actually really fucking irritating now? Because Justice Barrett wrote her thing as a concurrent, it feels like there wasn't pressure on Roberts to respond to any of it. I wonder if that factors into them writing concurring opinion or a dissenting opinion. Because if she would have wrote a dissenting in part, I feel like Roberts would have had to. Address her dissent, but now he basically just ignores all of it. But what is the core that they are concurrent on? The core issue that they're concurrent on is an issue that all of us should be concurrent on, is that the president should probably have some actions that are beyond judicial review, that are in his official capacity. That's fair. And she's concurring with that part, but she's saying, but hold on, but what you guys consider official actions is really wild. It's almost like, it's like you have a law that says police officers should be legally allowed to shoot people. And Roberts and Barrett both agree on this, but Roberts is saying that shoot can be anything. It could mean shooting a pistol, it could mean shooting a water gun, or it could mean shooting cum on them with your cock. And Barrett is like, I agree, he's right, cops should be able to shoot people. I mean, I basically agree with him completely, yeah. But I mean, it should probably only be bullets, not like the other stuff he's talking about. She's agreeing in part, but in my opinion, the trivial part of the ruling, even though it makes up the core of the ruling, that's not really a thing that I believe most legal people would have issue with. But, you know, I don't know. Well, does a 6-3 decision have more authority than a 5-4 decision? Nope. Some of those allegations raise unsettled questions about the scope of Article 2 power, but others do not. For example, the indictment alleges that the president asked the Arizona House Speaker to call the legislature into session to hold a hearing about election fraud claims. The president has no authority over state legislatures or their leadership, so it's hard to see how prosecuting him for crimes committed when dealing with the Arizona House Speaker would unconstitutionally intrude on executive power. Destiny, but even then you agree some official action can be questioned. You agree they can be examined for motive if a crime is alleged, right? Maybe. It would depend on how narrow you want to make those acts. If it's narrow enough, I could probably be fully on board with it. Or at least if I disagreed with it, I can see the argument that it's like, I don't really agree, but I get it. Yeah, I don't like it, but I get it. If it's narrow enough. But the wider that becomes, the more ridiculous the ruling becomes. It would be like if you take a guy who like never wants to be fucked in the ass ever, and it's like, okay, well, you have to be fucked in the ass. Do you want to be fucked with a 1-inch pencil, or do you want to be fucked with a 20-inch dragon dildo, right? And it's like, okay, well, if you're going to fuck me with a 1-inch pencil, fine, fuck it. I'm not really here for it, but whatever. But the dragon dildo is like significantly more anally expansive, or here, executive power immunity expansive, but... This two-step analysis, considering first whether the statute applies and then whether its application to the particular facts is constitutional, is similar to the approach that the special counsel presses in this court. It is also our usual approach to considering the validity of statutes in situations raising a constitutional question. An important difference in this context is that the president is entitled to an interlocutory appeal of the trial court's ruling. A criminal defendant in federal court normally must wait until after trial to seek review of the trial court's refusal to dismiss charges. But where trial itself threatens certain constitutional interests, we have treated the trial court's resolution of the issue as a final decision for purposes of appellate jurisdiction. Where was footnote 3? Wait, am I fucking blind? Oh, I see. The court has sometimes applied an avoidance canon when interpreting a statute that would interfere with the president's prerogatives. The Office of Legal Counsel has advocated for a clear statement rule if applying a statute would raise serious constitutional questions relating to the president's constitutional authority. In my view, neither canon applies in this circumstance. Courts should instead determine the statute's ordinary meaning and, if it covers the alleged official acts, assess whether prosecution would intrude on the president's constitutional authority. See public... Okay, that makes sense, right? Yeah. So, like, for instance, I don't know if this would be the path that ordinary legal stuff would take, but if somebody were to say, hold on, I want to sue like an FBI agent for kidnapping, and I want to point to this criminal thing or whatever, you say, well, hold on. Like if we look at how this crime is written and we look at who it applies to, and then we look at the power that's granted to this particular body, clearly there's a conflict here, but clearly the textual, interpretation of the power granted to the body means that they'd be exempt from said statute, or the statute itself. I guess she's saying now the courts are requesting that, well, hopefully these statutes just provide an exemption clause so that we can just, we don't have to deal with these issues in the courts at all. But
hello.
Hi, what's up?
Yeah, you said you'd be okay to discuss the Joe Biden-Trump debate a little bit.
Fuck, I lied. Tomorrow, okay? I'm still reading through this. Sorry, it's taking me a lot longer than I thought it would.
Okay.
I love you.
All right, take care. Make sure you feed your cats vegan. Bye-bye.
Got it. The present circumstances fall squarely within our precedent authorizing interlocutory review. When a president moves to dismiss an indictment on Article 2 grounds, he makes no challenge whatsoever to the merits of the charge against him. He instead contests whether the Constitution allows Congress to criminalize the alleged conduct, a question that is collateral to and separable from his guilt or innocence. Moreover, the president's executive branch authority would be significantly undermined if appellate review of the constitutional challenge were postponed until after conviction and sentence. The prospect of a trial court erroneously allowing the prosecution to proceed poses a unique danger to the independence of the executive branch. As the court explains, the possibility that the president will be made to defend his official conduct before a jury after he leaves office could distort his decisions while in office. These Article 2 concerns do not insulate the president from prosecution, but they do justify interlocutory review of the trial court's final decision on the president's as-applied constitutional challenge. I wonder then if she disagrees wholly with the absolute immunity claim. I'm curious if she mentions that, but or maybe she already has. I don't know. I understand most of the court's opinion to be consistent with these views. I do not join Part 3C, however, which holds that the Constitution limits the introduction of protected conduct as evidence in a criminal prosecution of a president beyond the limits afforded by executive privilege. I disagree with that holding on this score. I agree with the dissent. She's agreeing with Sotomayor. The Constitution does not require blinding juries to the circumstances surrounding conduct for which presidents can be held liable. Consider a bribery prosecution. Oh, and she's bringing up the one-legged stool example. Consider a bribery prosecution, a charge not at issue here, but one that provides a useful example. The federal bribery statute forbids any public official to seek or accept a thing of value for or because of any official act. The Constitution, of course, does not authorize a president to seek or accept bribes, so the government may prosecute him if he does so. Yet, excluding from trial any mention of the official act connected to the bribe would hamstring the prosecution. To make sense of charges alleging a quid pro quo, the jury must be allowed to hear about both the quid and the quo, even if the quo, standing alone, could not be a basis for the president's criminal liability. Now remember, even though Barrett is making this argument, the majority opinion disagrees, and that's not what's been forwarded by the court. The court is not concurring with Amy in this part. This is a part that she is disagreeing with the court on. So I appreciate the court's concern that allowing into evidence official acts for which the president cannot be held criminally liable may prejudice the jury, but the rules of evidence are equipped to handle that concern on a case-by-case basis. And see, Barrett is trusting a little bit more, as she should be, the federal prosecutorial guidelines. We have rules for evidence. You have interlocutory appeal in pretrial. You have rules for indictments. You have judges and prosecutors are involved. You've got many different steps here. Now, Roberts says, fuck all that shit. None of these guys can be trusted to deal with the exemplary office of the presidency. They would all be biased, and they'd all be corrupt, and they'd all be fucked. And Barrett is saying, well, hold on. There's a lot of stages in between this shit. There's probably other parts, as she said even earlier, that like even challenging a statute itself, these are, on whether they'd apply to the president, these are non-trivial steps, that are for review at every stage here, But the rules of evidence, okay. Most importantly, a trial court can exclude evidence of the president's protected conduct if its probative value is substantially outweighed by a danger of unfair prejudice or confusing the issues. Federal Rule of Evidence 403, see also Rule 105, requiring the court to restrict the evidence to its proper scope and instruct the jury accordingly. The balance is more likely to favor admitting evidence of an official act in a bribery prosecution, for instance, than one in which the protected conduct has little connection to the charged offense. And if the evidence comes in, the trial court can instruct the jury to consider it only for lawful purposes. See, blah, blah, blah. I see no need to depart from that familiar and time-tested procedure here. The Constitution does not insulate presidents from criminal liability for official acts. That's a departure from, in my opinion, probably the most important part of the majority rule, but okay. A criminal statute is no exception. Thus, a president facing prosecution may challenge the constitutionality of a criminal statute as applied to official acts alleged in the indictment. If that challenge fails, however, he must stand trial. We would say Barrett disagrees that official acts can't be probed or presented as evidence in a criminal trial, even if those particular acts would ordinarily be immune from criminal prosecution. Barrett also doesn't seem to agree with an expansive view on the absolute immunity argument forwarded by Roberts, but instead seems to view official conduct with a much more narrow lens, citing the conversations Trump has with election officials as falling squarely into private conduct, whereas Roberts remanded those questions to the lower courts. Now we have Sotomayor writing the dissent, joined by Kagan and Jackson. Sonia Sotomayor. Elena Kagan and I don't know their first names. Katanji, or is it Katani? Okay. Okay. Justice Sotomayor, with whom Justin Kagan and Justice Jackson join, dissenting. Today's decision to grant former presidents criminal immunity reshapes the institution of the presidency and makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law. Relying on little more than its own misguided wisdom about the need for bold and unhesitating action by the president, the court gives former President Trump all the immunity he asked for and more. Because our Constitution does not shield a former president from answering for criminal and treasonous acts, I dissent. I don't like the that quote from Thomas where he's like, nobody's above the law, including Trump. The law just says that Donald Trump is above the law, but he's not above the law because it's written into the law that he's above it, obviously, right? It's like, it's very circular. I just feel like it's kind of dumb, in my opinion, right? It would be like writing a constitution. This is like, oh, the king cannot be held criminally liable for anything ever. And then somebody's like, this is bullshit. You've got a king that's like above the law. And you're like, no, what are you talking about? The law literally says right there, the king just can't be held criminally liable, but it's part of the law, you dipshit. Like, well, you're kind of missing the point of what's being said, you know? Yeah, but feels a bit circular, in my opinion. That's such a disingenuous reading of Thomas's words. No, that's almost an exact quote from what Thomas said. In this case, there has been much discussion about ensuring that a president is not above the law. But, as the court explains, the president's immunity from prosecution for his official acts is the law. I'm almost quoting him verbatim. You dipshit, you uneducated fucking ape. Okay. Anyways. The indictment paints a stark portrait of a president desperate to stay in power. In the weeks leading up to January 6, 2021, then President Trump allegedly spread lies that there had been outcome determinative fraud in the election and that he actually won. Despite being notified repeatedly by his closest advisors that his claims were untrue. When dozens of courts swiftly rejected these claims, Trump allegedly pushed officials in certain states to ignore the popular vote, disenfranchise millions of voters, dismiss legitimate electors, and ultimately cause the ascertainment of and voting by illegitimate electors in his favor. It is alleged that he went so far as to threaten one state election official with criminal prosecution if the official did not find 11,780 votes. The 11,780 votes Trump needed to change the election result in that state. When state officials repeatedly declined to act outside their legal authority and alter their state election processes, Trump and his co-conspirators purportedly developed a plan to disrupt and displace the legitimate election certification process by organizing fraudulent slates of electors. As the date of the certification proceeding neared, Trump allegedly also sought to use the power and authority of the Justice Department to bolster his knowingly false claims of election fraud by initiating sham election crime investigations and sending official letters falsely claiming that the Justice Department had identified significant concerns that may have impacted the election outcome, while falsely presenting the fraudulent electors as a valid alternative to the legitimate electors. When the department refused to do as he asked, Trump turned to the vice president. Initially, he sought to persuade the vice president to use his ceremonial role at the January 6 certification proceeding to fraudulently alter the election results. When persuasion failed, he purportedly attempted to use a crowd of supporters that he had gathered in Washington, D.C. to pressure the vice president to fraudulently alter the election results. Speaking to that crowd on January 6th, Trump falsely claimed, based on fraud, the vice president could alter the outcome of the election results. When this crowd then violently attacked the Capitol and halted the proceeding, Trump allegedly delayed in taking any step to rein in the chaos he had unleashed. Instead, in a last desperate ploy to hold on to power, he allegedly attempted to exploit the violence and chaos at the Capitol by pressuring lawmakers to delay the certification of the election and ultimately declare him the winner. That is the backdrop against which this case comes to court. Up to this point, by the way, basically, so when people say, oh, well, how do we know that we're right and the conservatives aren't right? Like maybe we're the crazy ones, right? Aren't we both saying the other side is crazy? So the difference is conservatives don't deny any of this happening. All of this happened and they won't deny any of it. They'll just say that like, oh, well, it's not a big deal and he should have been allowed to do it. That's the difference, okay? If conservatives were the same conservatives they were 10 or 15 years ago, they would have the shame and they would have the wherewithal to at least deny the behavior, right? Like when a rapist gets caught raping somebody, right? That well, she consented. Well, she wanted me to fuck her. I didn't know that she didn't blah, blah, blah. But like when a conservative gets caught, it's like, so I should have the right to rape her. I don't give a fuck. That's the difference between today's like MAGA conservatives versus like the neocons in the past is the lack of shame, I would say. The court now confronts a question it has never had to answer in the nation's history. Wait, hold on, we need music. What am I looking for? Wasn't your argument that Biden shouldn't be able to be impeached for a quid pro with the Ukraine thing because it was an official policy? What official conduct can be prosecuted or impeached for? Do we need to do like a... You know what? Actually, I will write this. I'll do a note on this officially because I've dug into this a bit because conservatives just never seem to understand this. When Biden was saying that the United States wasn't going to provide aid unless Shokin was fired, the loan guarantees that the United States were providing were conditioned on Ukraine fixing up their prosecution system and the corruptness in that office. That's what that aid was conditioned on. That wasn't a quid pro quo. That wasn't him getting something for doing something. That's why he said it publicly and nobody thought anything about it at the time because everybody in the world understood that that's what the European Union, that's what the European nations, that's what the United States was pressuring Ukraine to do because Ukraine was one of the most corrupt, no offense, one of the most corrupt fucking countries in the world at the time, or at least in Europe. Current conversation. Oh. How naive. What did I just say that was incorrect? Okay. Okay. What did I just say that was incorrect is ironically a gotcha question to most conservatives. True. How convenient that he chose to have the prosecutor who was investigating his son fired. He wasn't investigating anything, my dude. You guys act like, okay, well, let's see. So what was going on? So Ukraine was the only country in the entire world except the United States. And then in Ukraine, there was one judge and he had one court case. And that court case was prosecuting one company, Burisma. And that company is owned and ran by and operated by one person, Hunter Biden. Wow. When Joe Biden was trying to get this prosecutor fired in the only other country on the planet just to save the only company that was ostensibly being investigated that is only ran or only has his son on it. Man, that's so crap. Bro, there's tons of moving pieces here. Like you're looking at one part of one company in one country, in one office, in one case of one part of the huge loan guarantees that the United States was making towards Ukraine. You're overplaying this so much that you think that, and by the way, that tie that it was being, that his firing, the pressure for that was even coming from Joe Biden at all is non-existent. By the way, there is no link, no evidence. The best you have is that Hunter Biden was in Burisma. That's it. There's not a single shred of evidence to even link that. Like, your theory is that Joe Biden somehow pressured Barack Obama and the rest of Europe to hate this prosecutor just to save Hunter Biden? Like, there is no such thing as the deep state. The deep state is literally just Hunter Biden, I guess. And he can, using the power of crack cocaine. Okay. The court now confronts a question it has never had to answer in the nation's history: whether a former president enjoys immunity from federal criminal prosecution. The majority thinks he should, and so it invents an atextual, ahistorical, and unjustifiable immunity that puts the president above the law. The majority makes three moves that, in effect, completely insulate presidents from criminal liability. First, the majority creates absolute immunity for the president's exercise of core constitutional powers. This holding is unnecessary. On the facts of the indictment,
And the majority's attempts to amplify it, the majority's attempt to apply it to the facts expands the concept of core powers beyond any recognizable bounds. In any event, it is quickly eclipsed by the second move, which is to create expansive immunity for all official acts. Whether described as presumptive or absolute, under the majority's rule, a president's use of any official power for any purpose, even the most corrupt, is immune from prosecution. Sorry, fuck, there's a hair on my fucking iPad. Triggering the fuck out of me. Okay. Even the most corrupt is immune from prosecution. That is just as bad as it sounds, and it is baseless. Finally, the majority declares that evidence concerning acts for which the president is immune can play no role in any criminal prosecution against him. Let me make sure that I... Okay, gotcha. Sorry, just make sure I have all this accounted for in my Robert's opinion thing. You could frame it as a quid pro quo, and one could not just brush it off. Even if no foul play at all, it's a talking point, and people chase quick dopamine releases nowadays. Okay, fine. If you want a quick dopamine release, then here we go. Under your quid pro quo idea, you're asserting that Joe Biden, the Vice President of the United States, has convinced Obama and the entire U.S. to fire one judge in Ukraine to save his son, okay? The level of expansive corruption there is massive. If he's willing to do all of that, why would Joe Biden allow his DOJ, his FBI to investigate his son, to charge his son, and then to convict him in a novel manner for a crime? I already know your answer, because you always have an answer. And the answer is, well, because it was so public this time, there's no way that they would have gotten away with it. There's no way they would have gotten away with it this time. That's your only answer. That's the only answer that you have. Like, I don't even, can you even bend your fingers anymore from how thick the calluses have to be on your knuckles from dragging them across the floor for the entirety of your existence to say something that fucking stupid? There would be flash flood warnings if people related to you were allowed to exist in a city because of how much fucking drool would come out of your mouth all fucking day long. How stupid you would have to be to answer that way. And it's the only answer you can give, okay? Extra strength, Drano. Okay, I'm never going to finish reading this. Finally, the majority declares that evidence concerning acts for which the president is immune can play no role in any criminal... Oh, did I write this down under Robert's things? Okay. Any immunity granted for any actions also means those actions cannot be used in the further, or cannot be reviewed even if they were used in the furtherance of another crime. I wonder if we could even toss the New York ruling with this. So what happens if everything you were saying is wrong? Will it be that you're still right and everyone else? Just show me what I'm wrong on then. All you have to do is show me how I'm wrong. Okay. Wasn't the New York one from before he was president? Oh, true, maybe, yeah. But who knows? Argument by argument, the majority invents immunity through brute force. Under scrutiny, its arguments crumble. To start, the majority's broad official acts immunity is inconsistent with text, history, and established understandings of the president's role. God, this is the same court that couldn't stand the concept. They couldn't stand the concept of the right to privacy, of unenumerated rights to citizens. Sorry. Okay. What do I know, bro? These guys know more than me about law. To start, the majority's broad official acts immunity is inconsistent with text, history, and established understandings of the president's role. Moreover, it is deeply wrong, even on its own functional terms. Next, the majority's core immunity is both unnecessary and misguided. Furthermore, the majority's illogical evidentiary holding is unprecedented. Finally, this majority's project will have disastrous consequences for the presidency and for our democracy. Infra means that it's like referenced within this document, right? That's essentially what it means, I think. Yeah, okay. So we've got Sotomayor argues in 5 parts. Is legally and historically inconsistent. It is deeply wrong, even in its own functionalist terms, that it is deeply wrong that the core immunity is misguided and not needed. The evidentiary holding is unprecedented. Doesn't necessarily make it bad, but that the ruling will have disastrous consequences. Hello?
Just real quick, just want to let you know, the judge in the New York hush money case, he has postponed sentencing until September because of the Supreme Court's decision. So yeah, it may affect it.
Why? They shouldn't affect him because these were actions taken before being president, right?
Well, I think the hush money payments occurred after, like the actual transactions themselves, if I remember correctly, they took place after he was elected.
So in the case where Donald Trump is so fucking late in paying any of his fucking bills, might have actually paid off for him.
Right. So I sent you the link, the official ruling from Judge Merchan, and you can check it out when you've got time.
Have you watched Ben Shapiro's video on this yet? I feel like I'm going to watch it. I'm going to lose my fucking mind. It's an hour long. Somebody linked it to me. I might, if I have time before then I showed it and I don't watch it, but oh boy.
No, I've not. And I just want to remind you, keep this in mind when you do watch his reaction, and you can check this out. I'll send you the link too. In 2014, he literally wrote a book calling for the prosecution of President Obama. So just keep all of that in mind, that 10 years ago.
Keep in mind that you know what Obama did that would be unreviewable?
Mm-hmm.
If Obama ordered the IRS to just tax conservatives, they shouldn't be able to review that action. In fact, they should fully say, well, hold on, we don't want to, infringe on the president's ability
to... It's an executive branch agency,
yeah,
right?
Exactly. Why the fuck would you have any review over that, right? Yeah, it's unbelievable, dude.
Yeah, so brace yourselves when you watch that.
Okay.
All right, buddy. I'll talk to you later.
Okay. Hold on, I gotta do something real quick. Actually, wait. Fuck it. I'm grabbing something real quick. Or ordering something.
So yesterday, pretty much...
I'll watch like the first few minutes of this while I order. What if Trump goes to jail but wins the election? What happens if New York refuses to release him? We have no clue. That's all uncharted territory.
All hell broke loose. It didn't break loose because of a Supreme Court decision. It broke loose because the left has decided, along with the media and the Democrats, but I repeat myself, to lie about the Supreme Court decision in order to revive the flagging hopes and dead body of Joe Biden. Let me begin at the beginning. Yesterday, the Supreme Court released a decision about presidential immunity. Now, this decision, of course, is rooted in Donald Trump filing a lawsuit to stop the various Jack Smith lawsuits against him. His claim was that as president of the United States, no matter what he did while he was president of the United States, he has full immunity from criminal prosecution. That, of course, is not true. That is a step too far. The idea that the President of the United States is never, for any activity, able to be criminally prosecuted is really silly. If the President of the United States decided that in his home, in the White House, he was just going to murder a maid, for example, could he be criminally prosecuted? The answer, of course, is yes. However, there is the idea that the President is, in fact, criminally immune from certain activities that a normal person would not be. So, for example, if I authorized somebody to go kill somebody abroad, I'd be criminally liable for that. If I'm President of the United States and as Commander-in-Chief, I authorize SEAL Team 6 to take out Osama bin Laden, I'm not going to be criminally liable for that. So there's plenty of stuff that the President of the United States...
What if you ordered SEAL Team 6 to kill your political opponent?
...has to be able to do in order to ensure the functioning of the executive authority of the United States. The President does have outsized powers under our Constitution. Those powers are not endless. Immunity is not eternal and endless. That is not the way that immunity works. And that's basically what the Supreme Court found. So in order to understand why the left is lying about this decision and why Joe Biden is lying about this decision and the political games that are now being played, you have to understand the decision itself from the Supreme Court. So I'm going to go through that decision in a little bit of detail because the sort of final effect of this as far as President Trump is that there are a couple of charges that Jack Smith has been pursuing that are basically DOA, and then there are several charges that are not DOA, and that will likely be upheld when this thing is reverted back to the D.C. Circuit Court of Appeals, because that's effectively what the Supreme Court did. They took a couple of charges. They said the president has immunity for this sort of activity, and then they said about many of the other charges, we're not going to rule whether the president has immunity on this sort of activity. We instead are going to send it back to the D.C. Circuit Court of Appeals to determine whether the president has immunity. Judge Chutkan is the judge in that particular case. Presumably, she's going to rule that President Trump does not have immunity on those particular charges. So, in essence, this is a very in-between decision. Now, you could have known that by the fact that the writer of the decision was Chief Justice Roberts. Chief Justice Roberts is, in fact, a fairly moderate justice. He is not Justice Samuel Alito. He is not Justice Thomas. He is not one of the more right-wing members of the federal judiciary. Remember, it was just...
To be clear, I don't know anything about like when Pisco says like the center of the court is, I think he said Roberts, or I don't know anything about like the political leanings or whatever, but just from and I've only read probably 4 Supreme Court decisions like cover to cover my life because I haven't had Vyvanse for very long, but from my reading, I feel like Barrett seems to come off as more reasonable. Roberts' opinion in this case is fucking unhinged. If Roberts is truly the center of the court, I don't know how you square, or maybe just in this particular decision, he's been a little bit more off the hook, but I feel like his decision is wild here. It would be crazy to think that this is like a moderate conservative decision on what federal powers should look like, in my opinion, but...
Hello.
Hello?
Hey.
Hi. What's up?
I was meaning to jump on at some point. I was actually just curious to get your opinion on the Supreme Court judges and like specifically Kavanaugh and Barrett and whether you think they're like as bad as they...
I have not read anywhere near enough opinions to be able to give like good, accurate evaluations of their rulings. So I wouldn't even begin to be able to, yeah. I would never trust anything I would say on that, yeah.
Gotcha. No gut feeling vibe check?
I mean, I like most of what I've seen from Barrett so far. Obviously, Sotomayor, she likes to write a lot. She seems based, but also I'm a liberal, so I might disagree with her in general. Actually, I am a little bit salty that the 3 of them changed their dissenting in parts to concurrences over the 14th Amendment thing, but otherwise, I don't know enough about any of these people to give you a good legal evaluation.
Gotcha. Okay. Yeah, no worries. I was just curious because I think, yeah, reading this Supreme Court decision, I'm kind of surprised that Barrett isn't more in line with what Roberts is, specifically because of the analysis you were talking about of people saying Roberts is a little bit more to the center. Because I think it's the case, right, that Barrett disagreed over the usage of the absolute immunity stuff for evidence for certain cases. Or
Yeah.
have you not finished reading through it yet?
Nope, I'm still reading through it, but...
Okay, gotcha. I'll hop back on later.
Okay.
I
love you. Be careful. Bye. Okay. fuck, I'm not going to finish this today. All right. Let's go. Sorry. Back to here, back to here. The main takeaway of today's decision is that all of the president's official acts defined without regard to motive or intent are entitled to immunity that is at least presumptive and quite possibly absolute. Whenever the president wields the enormous power of his office, the majority says, the criminal law, at least presumptively, cannot touch him. This official acts immunity has no firm grounding in constitutional text, history, or precedent, citing in Dobbs v. Jackson Women's Health Organization. Indeed, I wonder who she's citing here. Who the writer was for that. Indeed, those standard ground, is it him? Is it Roberts or? Indeed, those standard grounds for constitutional decision-making all point to the opposite direction. No matter how you look at it, the majority's official acts immunity is utterly indefensible. The majority calls for a careful assessment of the scope of presidential power under the Constitution. For the majority, that careful assessment does not involve the Constitution's text. I would start there. The Constitution's text, it's the majority by Alito, gotcha. The Constitution's text contains no provisions for immunity from criminal prosecution for former presidents. Of course, the silence of the Constitution on this score is not dispositive, U.S. v. Nixon, insofar as the majority rails against the notion that a specific textual basis is required. It is attacking an argument that has not been made here. The omission in the text of the Constitution is worth noting, however, for at least 3 reasons. Sorry, okay. First, the framers clearly knew how to provide for immunity from prosecution. They did provide a narrow immunity for legislators in the speech or debate clause. We did read this clause, yes, and that is indeed provided. They did not extend the same or similar immunity to presidents. That's interesting because the president does speak in Congress at times, right? When the president does like the State of the Union and stuff, that's in that's in the Capitol, right? I just assume it is. I don't know, maybe it's not. Where is the State of the Union given? It is. Okay, it is in the Capitol, right? Okay. Oh, maybe it was another fucking fancy building. Okay, just making sure. Destiny only read up to page 22 of the ruling. Michael Knowles read the ruling in all documents since the founding of America. True. Fuck. Yeah, I shouldn't have read your comment there. Can I just say that... Hold on. I can't tell if people know this. I need to not feel guilty doing this. I do feel bad doing it. I just stop. I need to just start quizzing people more. It's such a bad, it's a mean debate tactic. It's a mean debate tactic, but I need to just start doing it more. Because people do it to me. And I think that when people do it to me, you can quiz me because I know what the fuck I'm talking about. But I don't know if the audience is always understanding what's happened. We can't see. Yeah, I know. Hold on. Where is the link to the Michael Knowles thing? Where he tries to ask me. He's like, did you read the ruling? First of all, by the way, this ruling had come out like fucking 2 hours earlier. It's 120 pages. I don't think he read even a single page of this, okay? Bullshit. But Destiny Piers Morgan.
Talking about this. Remember, before the debate,
Biden's debate.
American.
What about Matt?
Most responsibility for 3 hours a night. I had a lot of.
At this point, obviously.
What did he say? Did he say read the ruling? What did he say? Show transcript. Read?
Destiny. Yes,
to be
the
clear,
Democrats
that is
are upset. They're
absolutely not true.
inveighing.
That this is
Just
based
let me
on
finish
precedent.
1 second, Destiny. They're inveighing because they say we should be talking about the immunity case. Well, but part of the articulation of I just was reading the decision was that look, this is the first time that you've got a president who's being prosecuted in this way, and that's the problem because the vast majority of Americans, right, left, and center, have been saying in survey after survey that they view the prosecutions of Trump as primarily politically motivated. They view this as kind of corrupt. And that's one of the reasons why Biden's poll numbers have been so bad for so long. And so they throw this Hail Mary to do a debate in June before either party has settled on a nominee. And it completely blew up in their face. And so no wonder people want to talk about it. You've got a political order that is fraying. You've got a guy trying to put his opponent into an orange jumpsuit. And it turns out the guy who's trying to do that has applesauce for brains. No wonder people
you know
are
what? The
concerned.
American people, a bit like the British, used to
was
get
it
stuff
not
to
here?
happen. The first ethic and you go, where we are with this. What do you think?
Replace Joe.
And that's right. See,
His guidance that this has been articulated by Joe Biden, and that should be able to put.
Come to you, then come back to Tom.
Going to have to seat a judge.
Democrat side. That's going to be polarizing. Is on
the way, but of what you want.
he sucks.
So someone else is running the country, whether that's Jill.
Control F20 or 25 pages. Oh wait, maybe it was over here. Hold on.
To bring in a bunch of, I don't know, drug dealers and hookers or something, that would probably be an unofficial crime, not related to his duties as president. And the reason that this matters, and why it's really a moderate decision, is because it goes back about 40 years.
Oh, he says it's a moderate. Okay.
Execution.
You do a. Have you read the decision?
What that act? No, it's just partial immunity for official act.
He did it. Hold on. I'm sorry. I just thought it was funny that.
What is an official act of the president? If you actually listen to the oral arguments that were presented before the Supreme Court, what that act even is, and the ability to even probe for it, is stuff right now that is now presumed to be immune. For instance, just a real quick thing. When Donald Trump is asking Pence, "Hey, can you throw out the election because I don't like the results?" which is a real thing that happened, by the way. As much as Trump would like to say that's not true, that is counted as an official action because these are the roles of the president and vice president, deciding how to count the electoral votes. That is insanity to me. If Biden were to do anything even remotely similar, Republicans would lose their minds.
Have you read the decision? I know it just came out this morning, but have you gone through the decision yet?
So the really funny thing is that if he would have read, so now that I've read the entire decision, I actually gave not the best example because the example that I gave is the one that Robert said would get presumptive immunity. The absolute immunity example I should have given was the attorney general conversation, not the conversation between Trump and Pence. So I know he hasn't read the decision at this point now because he wasn't able to give that counterexample to me when we spoke. But my example is still good enough. It's, suffice to say the presumptive immunity would have been similar enough to be used here. But he hasn't read it at all, so he can't even give that counterargument. But it's funny that, so he asks me this to try to get me to say, like, oh, I'm just a liberal. I can't read.
I read up to page 25, and part of it, I can read it out to you.
And then he laughed. Oh, you only read up to 25? You only read up to page 25? Like he's laughing, like he's read the whole 120 pages in the hour before we went live.
I read up to page 25, and part of it, I can read it out to you. He explicitly calls out that whenever the president and vice president discuss their official responsibilities, they engage in official conduct, meaning that presiding over the January 6th certification proceeding, at which members count, yes, so that did count as official conduct. So if you thought that he was trying to do a coup, try to steal the election by saying, hey, do you think you can throw those votes out? Well, that's beyond prosecution.
You can dispute or object to any action.
Clearly, he has not read it, and now he's fucking. But I don't know if people recognize what's happening here. When things like this are happening, he's shit testing me to see if I even knew what I was talking about, or if he could get me to admit. He's like playing chicken with me, right? He's like, "Oh, have you actually read it?" It's like, yeah, here's like a part that I'm referencing when I say that. He's like,
you can dispute or object to any actions that Trump takes, but it is simply the case that when a president is carrying out his.
But yeah, this. If people are going to do this to me, I should just do it back to them. Tell me what was your takeaway from that? But anyway, I feel like it makes me an asshole when I do it. I don't know. Anyway, when they quiz you, you answer succinctly and honestly. When you ask them even a basic question, they use it as an excuse to yap, yap, yap and dodge to something else. You must keep interrupting them even if they bitch about it. I can't, on Pures, I get like, he'll cut you off if you're like interrupting too much. They don't like it when you do it too much. So I was trying in this conversation, but there are multiple times you can hear like my mic gets lowered and then Piers keeps talking. I have to basically, yeah. But anyway, okay, sorry. It's taking us days to get through this. All right. Any shot you debate Knowles on Trump or Biden? I don't know. I'm taking a few days to do some shows, I think, on the 11th. One of the shows I'm doing on the 11th is going to be Michael Knowles' show. So we actually have a full show that we're doing on the 11th that I fly up to do. So, oh boy. But that's over. It's like a week and a half away. Unless he cancels because of our Piers Morgan appearances. They did not extend the same or similar immunity to presidents. Second, some state constitutions at the time of the framing specifically provided express criminal immunities to sitting governors. Brief for scholars of constitutional law at Amici Curiae. I don't know how to pronounce this. I'm not going to try, sorry. The frame, okay, that's actually a really strong historical argument, which originalists and textualists love to use. I think that's a good one to point. State constitutions, some state constitutions actually did provide for criminal immunity for sitting governors. This was not included in the U.S. Constitution. Whatever you do, Destiny, don't quote from the dissent. Nothing says I lost my argument as fast as reading from the dissent. Wait, what? Okay. The framers chose not to include similar language in the Constitution to immunize the president. If the framers had wanted to create some constitutional privilege to shield the president from criminal indictment, they could have done so. Third, insofar as the Constitution does speak to this question, it actually contemplates some form of criminal liability for former presidents. The majority correctly rejects Trump's arguments that a former president cannot be prosecuted unless he has been impeached by the House and convicted by the Senate for the same conduct. The majority ignores, however, that the impeachment judgment clause cuts against its own position. That clause presumes the availability of criminal process as a backstop by establishing that an official impeached and convicted by the Senate shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. That clause clearly contemplates that a former president may be subject to criminal prosecution for the same conduct that resulted or could have resulted in an impeachment judgment, including conduct such as bribery, Article 2, Section 4, which implicates official acts almost by definition. Article 2, Section 4 provides the president, vice president, and all civil officers of the United States shall be removed from office on impeachment for the conviction of treason, bribery, or other high crimes and misdemeanors. That's also a really compelling argument. Article 1, Section 2. Why do they use that weird S? What's this? The alt thing for that? Okay. Oh no, wait. Article 1, Section 3, Clause 7. That's the nevertheless for criminal prosecution. And things like bribery are official acts for which one can be impeached. So any citations of this part of the Constitution seem to imply that criminalizing official conduct was textually available or was textually supported by the Constitution. Aware of its lack of textual support, the majority points out that this court has recognized presidential immunities and privileges rooted in the constitutional tradition of the separation of powers and supported by our history. That is true as far as it goes. Nothing in our history, however, supports the majority's entirely novel immunity from criminal prosecution for official acts. The historical evidence that exists on presidential immunity from criminal prosecution cuts decisively against it. For instance, Alexander Hamilton wrote that former presidents would be liable to prosecution and punishment in the ordinary course of law. We read that yesterday in Federalist Number 69. For Hamilton, that was an important distinction between the King of Great Britain, who is sacred and inviolable, and the President of the United States, who would be amenable to personal punishment and disgrace. In contrast to the king, the president should be subject to personal responsibility for his actions, standing upon no better ground than a governor of New York, and upon worse ground than the governors of Maryland and Delaware, whose state constitutions gave them some immunity. At the Constitutional Convention, James Madison, who was aware that some state constitutions provided governors immunity, proposed that the convention consider what privileges ought to be allowed to the executive. There is no record of any such discussion. Delegate Charles Pinckney later explained that the convention which formed the Constitution well knew that no subject had been more abused than privilege, and so it determined to limit privilege to what was necessary and no more. No privilege was intended for the executive. Other commentators around the time of the founding observed that federal officials had no immunity from prosecution, drawing no exception for the president. Real quick, the footnote. To note, as the majority does, that the court has recognized civil immunities arguably inconsistent with this view is not to say that Pinckney was wrong about what the framers had intended. Indeed, Pinckney's contemporaries shared the same view during the ratification debates. And then the quote is, if the president does a single act by which the people are prejudiced, he is punishable himself. If he commits any crime, he is punishable by the laws of his country. Ooh, I wonder what the context of that quote is. Let's see. Article 2, Section 2, Clause 1. James Uredell, North Carolina ratifying convention. These are just minutes from the meeting, or from the debates, basically. Been the opinion of many gentlemen that the president should have a council. This opinion probably has been derived from the example in England. It'd be very proper for every gentleman to consider attentively whether that example ought to be imitated by us, although it would be a respectful example. It was very difficult immediately on a separation of Great Britain to disengage us entirely from the duties of government. We've been accustomed to a council under the old government and took it for granted that we ought to have one under the new. When they talk about a council here, are they talking about like a council that would be elected, or they're not talking about just like a cabinet appointed by the president? I'm guessing. They're talking about a council that comes from the parliament. Would be my guess. In that country, the executive authority is vested in a magistrate who holds it by birthright. He has great power. Oh, yes, because the council here would be limiting them by that definition, by that example, yeah. We've experienced that he can do no wrong, yet no man can say so in his own country. There are no courts. God, fuck. All of the initial conversations about the formation of like the structure of this country and the law and everything is so fucking based. It's so cool how intelligent these guys were and how much they were factoring when they were talking about the formation of the United States government. He has great powers and prerogatives, and it is a constitutional maxim that he can do no wrong. We have experienced that he can do wrong, yet no man can say so in his own country. There are no courts to try him for any high crimes, nor is there any constitutional method of depriving him of his throne. If he loses it, it must be by a general resistance of his people, contrary to forms of law, as at the revolution which took place about 100 years ago. It is therefore of the utmost moment in that country that whoever is the instrument of any act of government should be personally responsible for it, since the king is not. And for the same reason that no act of government should be exercised but by the instrumentality of some person who can be accountable for it. Everything, therefore, that the king does must be by some advice, and the advisor, of course, answerable. Under our Constitution, we are much happier. No man has an authority to injure another with impunity. No man is better than his fellow citizens, nor can we pretend to any superiority over the meanest man in the country. If the president does a single act by which the people are prejudiced, he is punishable himself, and no other man merely to screen him. If he commits any misdemeanors in office, he is impeachable, removable from office, and incapacitated to hold any office of honor, trust, or profit. If he commits any crime, he is punishable by the laws of his country, and in capital cases may be deprived of his life. Again, at the time also, this is a radical thing, right? You're creating a new government. You're coming from a king who can do no wrong to saying if we have a chief executive, we could literally execute him by our own laws. It's a huge 180 on, or turning on its head, the understanding of like a chief executor, I guess, or executive or a magistrate in any country. So he spells out both here, right? We have civil things, right? Or not, I'm so sorry, not civil things. We have impeachable offenses, right? That you can hold accountable by impeachment to remove from office. But also, and there are criminal things. There are criminal things of which you can be held accountable as well. This being the case, there is not the same reason here for having a council which exists in England. It is, however, much to be desired that a man who has such extensive and important business to perform should have the means of some assistance to enable him to discharge his arduous employment. The advice of the principal executive officers, which he can at all times command, will, in my opinion, answer this valuable purpose. He can at no time want advice if he desires it, as the principal officers will always be on the spot. There's also like good answers too. You know, one of the things people say, like, oh, like these are unelected people, these are unelected officials. Like my response has always been, well, you know, it's like it is a democracy. Like you're electing the president and he appoints people. So like to say that it's not a democracy because he appoints people is stupid. Like, and that is a decent answer. But like the more historically informed answer is, why would you want to elect co-equal members of power in the executive branch? Our government is explicitly designed that one man heads the executive. That is the explicit design of our government. And to vote with people with unanswerable power to other executives in the executive destroys the entire function by which the executive branch was founded. That's like a better, more informed, more historical answer. I personally just never considered. I guess this in real time is me exploring or discovering or finding out what I said before, where it's like when you read some things, it's like, well, this is kind of dumb. And then you look into it a little bit more, you're like, oh, okay, it makes sense, I guess. But I guess, or I'm sorry, the other thing. Well, you think about a thing and it's like, yeah, it makes sense that there are a bunch of offices in the executive, and then you think about it and it's like, well, these people are unelected. Why is the FDA unelected? Why is this guy unelected? But then understanding the historical thing, it's like, okay, well, you can't have an executive that has other people sharing power that would turn the executive against itself. That check should come from the legislative. If the executive is to execute power from the legislative, it should be unquestioned in the executive, right? Yeah. Yeah, that would be the historical American founding argument for how our government is designed. But Sotomayor's citation here, in my opinion, and maybe I'm biased because I agree with her dissent, but in my opinion, the things that she cites to are much stronger advancements of her argument in terms of what's being written about than the one-line citations that were given by Roberts and Thomas, in my opinion. But be that as it may. Okay. Other commentators around the time of the founding observed that federal officials had no immunity from prosecution, drawing no exception for the president. James Wilson recognized that federal officers who use their official powers to commit crimes may be tried by their country, and if the criminality is established, the law will punish. A grand jury may present, a petty jury may convict, and the judges will pronounce the punishment. Interesting. A few decades later, Justice Story evinced the same understanding. He explained that when a federal official commits a crime in office, it is indispensable that provision should be made that the common tribunals of justice should be at liberty to entertain jurisdiction of the offense for the purpose of inflicting the common punishment applicable to unofficial offenders. Sotomayor. Why do I have her name spelled incorrectly? Makes reference to other historical arguments that support to the criminal charging of public officials acting in their official capacity. That the common tribunals should be at liberty to entertain jurisdiction of the offense. Okay, boom, boom, boom. Okay. This historical evidence reinforces that, from the very beginning, the presumption in this nation has always been that no man is free to flout the criminal law. The majority fails to recognize or grapple with the lack of historical evidence for its new immunity. With nothing on its side of the ledger, the most the majority can do is claim that the historical evidence is a wash. It claims that the court previously has described the relevant historical evidence on the question of presidential immunity as fragmentary and not worthy of consideration. Yet the court has described only the evidence regarding the president's immunity from damages liability as fragmentary. True. That when she says, they say damages liability, when they're talking about that in the Supreme Court, they are exclusively referencing civil matters, right? Legal guy, correct me if I'm wrong. When you're talking about like paying damages or damages liability, you're talking about civil matters between two citizens, not a violation of a criminal statute. You don't pay damages, you pay fines, right? You don't. If somebody sues me for overdue rent, I don't pay a fine. I pay damages, right? I pay would you say restitution maybe? No, restitution might be a court thing too to make something right. But you don't pay like damages. But if I get a criminal charge and then there's a fine that goes with my imprisonment, it's a fine. I'm not paying damages to the state. Although a state might be able to take you to civil court for violation of something as well. But anyway. Moreover, far from dismissing that evidence as irrelevant, the Fitzgerald court was careful to note that the best historical evidence clearly supported the immunity from damages liability that it recognized, and it relied in part on that historical evidence to overcome the lack of any textual basis for its immunity. The majority ignores this reliance. It seems history matters to this court only when it is convenient. See New York State Rifle and Pistol Association versus Bruin and Dobbs. True. Absolutely true and based. Okay? This was a bananas ruling, okay, from the fucking majority. It seems like they only I've said this many times. Like history and text only matters when it supports our argument. But whatever. We've heard this many times. So fuck this. Okay. Our country's history also points to an established understanding shared by both presidents and Justice Department that former presidents are answerable to the criminal law for their official acts. Oh, this wasn't even the history part? Can you explain why the Dobbs decision was bad? I will tread lightly on Dobbs because I wasn't amphetamine up for Dobbs, so I didn't read all of Dobbs. I might have read the summary part. But I think the issue people had with Dobbs is the conservative court wanted to fight against unenumerated powers. No, it wouldn't be unenumerated powers. I'm sorry. The concept of like a penumbra of rights, basically the idea that through reading some amendments, you could kind of fabricate these rights out of thin air. Things like the right to privacy, that you could get them through a reading of other amendments. It seemed like the court was very against those types of atextual readings and those implications. They don't like, they say, well, we need like a stronger historical foundation, or we need like a stronger textual foundation in order to justify things like Roe v. Wade, or in order to justify Casey v. Planned Parenthood. But for this case, they have entirely fabricated with no historical foundation and with no textual support the idea of unrestricted absolute immunity for official presidential acts. That's a pretty big meme. But let's see. We're quoting this. Long settled and established practice may have great weight in a proper interpretation of constitutional provisions, quoting the pocket veto case. Consider Watergate, for example. After the Watergate tapes revealed President Nixon's misuse of official power to obstruct the Federal Bureau of Investigation's misuse of official power to obstruct the Federal Bureau of Investigation's investigation of the Watergate burglary, President Ford pardoned Nixon. Both Ford's pardon and Nixon's acceptance of that pardon necessarily rested on the understanding that the former president faced potential criminal liability. I don't know how you ever get around this. I don't know how you could possibly get around that. I have no clue how you get around that. I don't know. Did Roberts even touch this? I don't think Roberts even touched Nixon except for to borrow quotations from it to try to support criminal liability when they were talking about civil liability. Like, ugh. Granting former President Nixon a full, free, and absolute pardon for all offenses against the United States which he has committed or may have committed or taken part in during his presidency. Accepting full and absolute pardon for any charges which might be brought against me for actions taken during the time I was President of the United States. So that was Nixon's acceptance of that pardon. I'm independent. In the Piers video, it seems you're saying that you would rather us vote for a cabinet instead of a person, which has never happened. You're always voting for the president and his cabinet. That's literally always happening. That's what the executive branch is. Subsequent special counsel and independent counsel investigations have also operated on the assumption that the government can criminally prosecute former presidents for their official acts. Oh, actually, you know what would have been a good citation for the... I'm actually surprised that the majority opinion didn't further this opinion. Did Mueller refuse to recommend charges partially on the understanding that a sitting president couldn't be indicted? But that was for a sitting president. I'm still surprised it wasn't brought up, but I don't know. Yes, but not entirely the cabinet. That is what the Democrats seem to be asking us to do. Maybe, I don't know. I haven't seen any evidence that Biden can't perform the functions of the president of the United States. Can he debate? Well, maybe not, but he seems to be able to give speeches. The country seems to be running. He seems to be the president as much as anything else. I haven't seen evidence that he's incapable of performing the roles of that job, unless you're going to rest everything on his performance in a singular debate, in which case... I will say that it is very funny, I said this on Piers Morgan, that all these people that I argue and debate with all day tell me that debate means nothing, debate doesn't matter, debate is irrelevant, but apparently now debate is literally the most job-determinative thing that any individual can actually do, and your performance in a debate is the most important aspect of your job. But subsequent special counsel and independent counsel investigations have also operated on the assumption, let's see, President of official act, they violate criminal law, Contra matters, Iran-Contra, because a president, and certainly a past president, is subject to prosecution. The conduct of President Reagan in the Iran-Contra matter was reviewed by independent counsel against the applicable statutes. It was concluded that his conduct fell well short of criminality, which could be successfully prosecuted. Okay. What if Nixon's Republican campaign officials' crime wasn't an official act? And what if that unofficial act didn't immunize him for prosecution? The majority opinion wouldn't comment on that, as it wasn't before the court. Okay. Indeed, Trump's own lawyers, during his second impeachment trial, assured senators that declining to impeach Trump for his conduct related to January 6th would not leave him in any way above the law. Oh, true. Proceedings of the U.S. Senate in the impeachment trial of Donald J. Trump, they insisted that a former president is like any other citizen and can be tried in a court of law. Trump's impeachment counsel stating that no former officeholder is immune from the judicial process for investigation, prosecution, and punishment. If my colleagues on this side of the chamber actually think that President Trump committed a criminal offense after he is out of office, you go and arrest him. Jesus. Now that Trump is facing criminal charges for those acts, though, the tune has changed. Being treated like any other citizen no longer seems so appealing. In sum, the majority today endorses an expansive vision of presidential immunity that was never recognized by the founders, any sitting president, the executive branch, or even President Trump's lawyers until now. Settled understandings of the Constitution are of little use to the majority in this case, and so it ignores them. Setting aside that evidence, the majority announces that former presidents are absolutely, or at least presumptively, immune from criminal prosecution for all of their official acts. The majority purports to keep us in suspense as to whether immunity is absolute or presumptive, but it quickly gives up the game. It explains that at a minimum, the president must be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. God, that's saying, what does that mean? No dangers, not little dangers, not only some dangers, not minor dangers, no dangers of intrusion? Oh, and she says it as much, yeah. No dangers, none at all. It is hard to imagine a criminal prosecution for a president's official acts that would pose no dangers of intrusion on presidential authority in the majority's eyes. Nor should that be the standard. Surely some intrusions on the executive may be justified by an overriding need to promote objectives within the constitutional authority of Congress. Other intrusions may be justified by the primary constitutional duty of the judicial branch to do justice in criminal prosecutions. Jesus Christ. Oh, and she's citing that Nixon case as well. Oh, so for the Nixon case, they even give tests. Huh. Okay, hold on real quick. Okay, I'm trying to describe broad Supreme Court shit. If an attorney disagrees with me, feel free to correct me, or a constitutional scholar, or somebody know, whatever. Somebody said, isn't the Supreme Court procrastinating dealing with the issue of what is an official action? They said the lower courts have to decide whether an act is official or unofficial, but Trump is going to dispute the results, so won't it inevitably go back to the Supreme Court? The Supreme Court is supposed to be the last stop for consideration of an issue. It's not supposed to be the first body that considers a particular thing as a general principle. So I think the Supreme Court is saying, listen, you guys are going to do the fact pattern to determine if it's an official or unofficial act, and then you guys are going to try to develop like a test or develop some way to figure out if you think it should be considered an official or unofficial act. And then when it gets to us, assuming it's still appealed, we'll look at it, we'll give it a review, and then we'll determine if we like it or we don't like it, basically. But the Supreme Court is not supposed to be, in principle, the first stop for those types of questions. It's supposed to be taken up by lower courts first, and then only given to the Supreme Court for final review, basically. Other intrusions may be just blah, 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 blah. Okay. According to the majority, however, any incursion on executive power is too much. When presumptive immunity is this conclusive, the majority's indecision as to whether official acts immunity must be absolute or whether instead presumptive immunity is sufficient hardly matters. Maybe some future opinion of this court will decide that presumptive immunity is sufficient and replace the majority's ironclad presumption with one that makes the difference between presumptive and absolute immunity meaningful. Today's court, however, has replaced a presumption of equality before the law with a presumption that the president is above the law for all of his official acts. Quick on the heels of announcing this astonishingly broad official acts immunity, the majority assures us that a former president can still be prosecuted for unofficial acts. Of course he can. No one has questioned the ability to prosecute a former president for unofficial, otherwise known as private, acts. Even Trump did not claim immunity for such acts, and, as the majority acknowledges, such an immunity would be impossible to square with Clinton v. Jones. This unremarkable proposition is no real limit on today's decision. It does not hide the majority's embrace of the most far-reaching view of presidential immunity on offer. In fact, the majority's dividing line between official and unofficial conduct narrows the conduct considered unofficial almost to a nullity. It says that whenever the president acts in a way that is not manifestly or palpably beyond his authority, he is taking official action. He then goes a step further in dividing official from unofficial conduct. Courts may not inquire into the president's motives. It is one thing to say that motive is irrelevant to questions regarding the scope of civil liability, but it is quite another to make it irrelevant to questions regarding criminal liability. Under that rule, any use of official power for any purpose, even the most corrupt purpose indicated by objective evidence of the most corrupt motives and intent, remains official and immune. Under the majority's test, if it can be called a test, the category of presidential action that can be deemed unofficial is destined to be vanishingly small. So she would say the difference between an official and unofficial act, the inability to probe motives or intents of anything that can be even slightly construed as an official act essentially nullifies almost all criminal law from applying to almost all presidential actions. Ultimately, the majority pays lip service to the idea that the president charged with enforcing federal criminal laws is not above them, but it then proceeds to place former presidents beyond the reach of the federal criminal laws for any abuse of official power. So how does the majority get to its rule? Biden spends 90 unscripted minutes in public and is objectively senile. To now say that his obvious senility is failing at debating is so disingenuous that you and Harry Sisson should make out. That's great. So how does the majority get to its rule? With text, history, and established understanding all weighing against it, the majority claims just one arrow in its quiver. The balancing test in Nixon v. Fitzgerald, which, remember, Nixon v. Fitzgerald is a case concerning civil liability, damages for civil matters, not criminal liability, offenses against the state, okay? Or against citizens that the state has deemed wrong. Yet even that test cuts against it. The majority concludes that official acts immunity is required to safeguard the independence and effective functioning of the executive branch by rejecting that branch's own protestations that such immunity is not at all required and would in fact be harmful. In doing so, it decontextualizes Fitzgerald's language, ignores important qualifications, and reaches a result that the Fitzgerald court never would have countenanced. In Fitzgerald, plaintiff A. Ernest Fitzgerald sued then former President Nixon for money damages. He claimed that, while in office, Nixon had been involved in unlawfully firing him from his government job. The question for the court was whether a former president had immunity from such a civil suit. The court explained that it was settled law that the separation of powers doctrine does not bar every exercise of jurisdiction over the President of the United States. To determine whether a particular type of suit against a president could be heard, a court must balance the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch. That balancing test is so much different than the one proposed by Roberts in the majority opinion. Like, notice here the difference in language, right? Here, the court is saying, that court was saying that you have to balance the weight of the interest to be served against the dangers of the intrusion. Whereas the court today is saying any intrusion is not acceptable, period, full stop. There is no balance. There's just a test to see if there's any intrusion into the executive's ability to perform at all. Destiny keeps harping on the civil comparison. Criminal law is considered to be more serious than civil law, so if you are granting immunity for civil, you would also grant immunity in criminal. I fully disagree. Criminal law as a category of things, I think, can be more severe than civil law, because as a category of things, criminal law is oftentimes regarding or talking about a deprivation of rights guaranteed to you by the Constitution. That's what criminal law results in you losing, essentially, right? Are these rights afforded to you by the Constitution? However, the threshold for charging criminal law is also, as a result, much higher. The threshold for an indictment and the threshold for a conviction are much higher. So to say that someone is entitled to civil immunity because it would make their job impossible, to say that it logically follows that they should also have all criminal immunity as well, I don't believe that logically follows. I've said this a million times. That's bullshit. Okay, sorry. Destiny, you can disagree, but that is how it works in the real world. That's why there is general criminal immunity with regards to certain government employees. Then you go done to civil. I'm sorry, David, what the fuck are you talking about? Can you cite me what you're referring to? Because apparently you're so fucking smart that you have understandings of criminal law that exceed even the Supreme Court. Because whatever you're referring to, where there is absolute criminal immunity provided to government officials, please cite what you're talking about, because nobody here in any of the Supreme Court knows what the fuck you're talking about, because I haven't seen any of those citations. So please share with us and email fucking Roberts while you're at it for whatever the fuck you're referring to. Please give us. Please tell me, what are you referring to? I don't know. Why am I even looking at chat expecting you to cite anything? If nobody in the Supreme Court knows what the fuck that you're talking about, why the fuck would I expect you to have it? Yeah, Jesus. Yes, all judges have absolute immunity for the work that they conduct from the bench? Absolute criminal immunity or absolute civil immunity? Because that immunity for judges was brought up, but I believe that was just civil. Let me check. Do judges have absolute criminal immunity on the bench? Judicial immunity and liability. This is for the Florida Judicial College. Judicial immunity shields judicial officials from damages, that means civil, flowing from, maybe there's a criminal thing here, flowing from acts taken while administering their judicial duties. The immunity is absolute immunity from suit, not just from the ultimate assessment of damages for judicial acts, even if the judge's exercise authority is flawed by the commission of grave procedural errors. The doctrine of judicial embraces persons who exercise a judicial or quasi-judicial function. Yes, okay. So this is just from damages. This is from civil stuff, not criminal stuff. Okay. Go further. Does any of this talk about criminal? I don't think any of this. It looks like all of this has to do with civil, like with damages related stuff. Yeah, I don't know. Yeah, I don't think that there is. I don't think that exists. Okay. Make them research. I don't know why you're researching for them. Sure. Okay. On the facts before it, the court concluded that a merely private suit. Oh, wait. The court explained that when judicial action is needed to serve broad public interest, as when the court acts, not in derogation of the separation of powers, but to maintain their proper balance, or to vindicate the public interest in an ongoing criminal prosecution, the exercise of jurisdiction has been held warranted. On the facts before it, the court concluded that a merely private suit for damages based on a president's official acts did not serve those interests. The court reasoned that the visibility of the president's office and the effect of his actions on countless people made him an easy target for civil suits that frequently could distract him from his public duties. The public interest in such private civil suits, the court concluded, was comparatively weak. That's important. Remember, public interest. When we talk about criminal matters, I believe the assumption is that there is a big public interest. The public has a huge interest in, well, maybe, I don't know, fuck. We'll see what she says, sorry. Pretty sure. There is a lesser public interest in actions for civil damages than, for example, in criminal prosecutions. Oh, okay, yeah, fuck you. Then, for example, in criminal prosecutions. Therefore, the court held that a former president was immune from such suits. In the context of a federal criminal prosecution for a former president, however, the danger to the functioning of the executive branch is much reduced. Further, as every member of the Fitzgerald Court acknowledged, the public interest in a criminal prosecution is far weightier. Applying the Fitzgerald balancing here should yield the opposite result. Instead, the majority elides any difference between civil and criminal immunity. Based, yes. Granting Trump the same immunity from criminal prosecution that Nixon enjoyed from an unlawful termination suit. That is plainly wrong. Yes. Pre-read. I did pre-read this. These are the 25 pages I read. The majority relies almost entirely on its view of the danger of intrusion. I should probably write this down. if since the public has a greater interest in criminal prosecution than it does in private suits, the executive branch should need to provide a greater reason, not a lesser one, to evade such liability. The majority relies almost exclusively on its view of the danger of intrusion on the executive branch, to the exclusion of the other side of the balancing test. Yes, why wasn't the public interest ever addressed? Even in addressing the dissent, I feel like they don't ever address the other side of the equation. It is true, and we should all acknowledge, that we do want there to be an executive that can function free of worry of frivolous, even criminal suit. Sure, fuck it. We don't need like the president worrying about whether or not, I don't know, he's breaking his speed limiters. I don't know, just something frivolous or stupid that we wouldn't want him to be considering this when he's serving his role as president. But we also don't want a president that thinks he can infinitely commit criminal acts. We don't want that either. The public has a huge interest in not having a criminal president. Arguably, that is one of the largest public interests. He is the executor of law. Why would, of all the people who could commit criminal acts, is the king not the one that we are the most worried about? I don't think that's ever addressed a single time in the majority or either of the concurring opinions. But its analysis rests on a questionable conception of the president as incapable of navigating the difficult decisions his job requires while staying within the bounds of the law. It also ignores the fact that he receives robust legal advice on the lawfulness of his actions. Also true, there's a whole office. We cited an opinion earlier about Obama drone striking somebody. There's a whole office that that confers with the president over the legality of a particular action. I know you're not done, but Noah Smith retweeted this thread of the Supreme Court decision. Do you largely agree? TLDR, it's bad, but some people are overhyping this into saying the SEAL Team 6 assassinating opponents being legal is dumb. Here comes like the liberal contrarians that want to pretend that, oh, everybody's doomsaying, so we're going to show how we're actually not doomsaying by being so reasonable and based, by being contrarian retards. It's like the people that anti-fan me in my community that want to show they're not just dusty dick riders. But okay. Okay, that's a... The majority says that the danger of intrusion on the authority and functions of the executive branch posed by criminally prosecuting a former president for official conduct is akin to, indeed, greater than, what led us to recognize absolute presidential immunity from civil damages liability, that the president would be chilled from taking the bold and unhesitating action required of an independent executive. It is, of course, important that the president be able to deal fearlessly and impartially with the duties of his office. If every action the president takes exposes him personally to vexatious private litigation, the possibility of hamstringing presidential decision-making is very real. Yet, there are many facets of criminal liability, which the majority discounts, that make it less likely to chill the presidential action than the threat of civil litigation. First, in terms of probability, the threat of criminal liability is much smaller, yes. In Fitzgerald, the threat of vexatious civil litigation loomed large. This is why I said I wish that Roberts would have given us examples. What are all of these examples of potential, criminal issues that the president could run into in the ordinary course of performing core presidential duties? Can you give even one example? But you should give several. What actions of the president are being chilled by making them criminally liable? I don't think they gave a single one in the majority or the concurrence. Why? What would it be? We should have questions for debates. Can you give a single example of an action a president might want to take that would be chilled by him being criminally liable, even for core actions, even for the core functions of his office? Hold on. Let me use the restroom real quick. Okay. Been spamming Destiny all day, even $2 donation. How the Fifth Amendment doesn't end all these... How does the Fifth Amendment not end all these stupid SEAL Team 6 hypotheticals? What are you talking about? You don't need to commit a crime for the commander-in-chief to kill you for matters of national security. There doesn't have to be a crime committed for the military to act against you. That was his last $2. Abraham Lincoln suspended habeas corpus. No, yeah, he did, but I don't know what all the the process for. I just don't like to cite the things that I'm not like intimately familiar with. I'm so hesitant to, yeah. The Fifth Amendment is the right to life and liberty and stuff. Okay, I don't know how that impacts. Okay. Habeas corpus can be suspended during times of civil war. Okay, where was I? Sorry. First, in terms of probability, the threat of criminal liability is much smaller. In Fitzgerald, the threat of vexatious civil litigation loomed large. The court observed that, given the visibility of his office and the effect of his actions on countless people, the president would be an easily identifiable target for suits for civil damages. Actions on countless people could result in untold numbers of private plaintiffs suing for damages based on any number of presidential acts in the civil context. The risk in the criminal context is only that a former president may face one federal prosecution in one jurisdiction for each criminal offense allegedly committed while in office. The majority's bare assertion that the burden of exposure to federal criminal prosecution is more limiting to a president than the burden of exposure to civil suits does not make it true, and it is not persuasive. Yeah, so this is my argument where I was saying, like, if I had to choose between immunity from civil suits or criminal suits, I would want immunity from civil suits. Like, it's easy to not commit a crime. It might be incredibly difficult not to open yourself up to liability from civil damages, right? That's why I agree with, I think this argument is much more persuasive. Second, federal criminal prosecutions require robust procedural safeguards not found in civil suits. The criminal justice system has layers of protection that filter out insubstantial legal claims, whereas civil litigation lacks analogous checks. To start, the Justice Department policy requires scrupulous and impartial prosecution founded on both the facts and the law. See generally the Department of Justice, blah, blah, blah. The grand jury provides an additional check on felony prosecutions, acting as a buffer or referee between the government and the people to ensure that the charges are well-founded. In a dissenting opinion, a criminal prosecution cannot be commenced absent careful consideration by a grand jury at the request of a prosecutor. The same check is not present with respect to the commencement of civil suits in which advocates are subject to no realistic accountability. Let's see, what would this even go under? There are many more safeguards and protections built into criminal suits versus private action. Wait. What Jody just linked in chat. Is there a football game going on right now? If the prosecution makes it past the grand jury, then the former president still has all the protections our system provides to criminal defendants. If the former president has an argument that a particular statute is unconstitutional as applied to him, then he can move to dismiss the charges on that ground. Indeed, a former president is likely to have legal arguments that would be unavailable to the average criminal defendant. For example, he may be able to rely on a public authority exception from particular criminal laws, or an advice of the Attorney General defense. See this argument. Okay. Let's see. This thing, explaining that public officers may be impliedly excluded from statutory language embracing all persons. If reading the statute to include such officers would work obvious absurdity. For example, the application of a speed law to a policeman pursuing a criminal or the driver of a fire engine responding to an alarm. See also memorandum from acting assistant general, interpreting criminal statute prohibiting unlawful killings to incorporate the public authority justification, which can render lethal action carried out by a government official lawful in some circumstances. And then footnote 4, Trump did not raise those defenses in this case, and the immunity that the majority has created likely will obviate the need to raise them in future cases. Yet those defenses would have protected former presidents from unwanted criminal prosecutions much more precisely than the blanket immunity the majority creates today. Fuck. If I read every day, do you think my voice will become more adapted to it? Jesus. If the case nonetheless makes it to trial, the government will bear the burden of proving every element of the alleged crime beyond a reasonable doubt to a unanimous jury of the former president's fellow citizens. If the government manages to overcome even that significant hurdle, then the former... Fuck, I didn't mean to push that. If the government manages to overcome even that significant hurdle, then the former president can appeal his conviction, and the appellate review of his claims will be particularly meticulous. He can ultimately seek this court's review, and if past practice, including in this case, is any indication, he will receive it. In light of these considerable protections, the majority's fear that bare allegations of malice would expose former presidents to trial and conviction is unfounded. God, that's such a stupid fucking quote. Bare allegations of malice would not make it out of the starting gate. True, it's not a civil case, it's a criminal one, which is why the Fitzgerald comparisons are so inappropriate, in my opinion. Although a private civil action may be brought based on little more than intense feelings, quoting Fitzgerald, a federal criminal prosecution is made of firmer stuff. Certainly there has been, on occasion, great feelings of animosity between incoming and outgoing presidents over the course of our country's history. Yet it took allegations as grave as those at the center of this case to have the first federal criminal prosecution of a former president. That restraint is telling. Yes, this is what I said before. Like, if we were worried about infinite criminal prosecution of past presidents, well, why hasn't it happened yet? Apparently, it's been possible up to this point. Why hasn't it happened? That's a good debate question. We are so worried about presidents infinitely prosecuting prior presidents for criminal matters. Why has it not happened yet? Despite the Supreme Court, why has it not happened yet? Why was Nixon pardoned by Ford? Wait, no. Why did Ford find it necessary to pardon Nixon? And why did Nixon accept the pardon if Nixon believed he was immune to criminal prosecution? If the president was assumed immune from criminal prosecution for acts taken as president. Third, because of long-standing interpretations by the executive branch, every sitting president has so far believed himself under the threat of criminal liability after his term in office and nevertheless boldly fulfilled the duties of his office. The majority insists that the threat of criminal sanctions is more likely to distort presidential decision-making than the potential payment of civil damages. If that is right, then that distortion has been shaping presidential decision-making since the earliest days of the Republic. Yes! True. Although it makes sense to avoid diversion of the president's attention during the decision-making process with a needless worry, one wonders why requiring some small amount of his attention or his legal advisor's attention to go towards complying with federal criminal law is such a great burden. If the president follows the law that he must take care to execute of Article 2, as Article 2, Section 3 says, he has not been rendered unduly cautious. Some amount of caution is necessary after all. It is a far greater danger if the president feels empowered to violate federal criminal law, buoyed by his knowledge of future immunity. I am deeply troubled by the idea inherent in the majority's opinion that our nation loses something valuable when the president is forced to operate within the confines of federal criminal law. So what exactly is the majority worried about deterring when it expresses great concern for the deterrent effect that the threat of trial, judgment, and imprisonment would pose? It cannot possibly be the deterrence of acts that are truly criminal. True. Nor does it make sense for the majority to wring its hands over the possibility that presidents might stop and think carefully before taking actions that borders on criminal. Instead, the majority's main concern could be that presidents will be deterred from taking necessary and lawful actions by the fear that their successors might pin them with a baseless criminal prosecution, a prosecution that would almost certainly be doomed to fail if it even made it out of the starting gate. The court should not have so little faith in this nation's presidents. As this court has said before in the context of criminal proceedings, the chance that now and then there may be found some timid soul who will take counsel of his fears and give way to their repressive power is too remote and shadowy to shape the course of justice. Quoting Clark v. United States, that was quoted in the Nixon case. The concern that countless and baseless civil suits would hamper the executive may have been justified in Fitzgerald, but a well-founded federal criminal prosecution poses no comparable danger to the functioning of the executive branch. Does diplomatic immunity grant criminal immunity? I don't know how diplomatic immunity works at all. Wait, what the fuck is this? Wait, what is this? The Friday show at the RNC in Milwaukee. Okay. Maybe. I don't even know what that is. Okay. Page 86. At the same time, the public interest in a federal criminal prosecution of a former president is vastly greater than the public interest in a private individual civil suit. All 9 justices in Fitzgerald explicitly recognized that distinction. The 5-justice majority noted that there was a greater public interest in criminal prosecutions than in actions for civil damages. Chief Justice Berger's concurrence accordingly emphasized that the majority immunity was limited to civil damages claims rather than criminal prosecution. The 4 dissenting judges agreed that a contention that the president is immune from criminal prosecution in the courts, if ever made, would not be credible. At the very least, the Fitzgerald court did not expect that its balancing test would lead to the same outcome in the criminal context. The public's interest in prosecution is transparent. A federal prosecutor herself acts on behalf of the United States. Even the majority acknowledges that the federal criminal laws seek to redress a wrong to the public as a whole, not just a wrong to the individual. Such that there is a compelling public interest in fair and effective law enforcement. Indeed, our historic commitment to the rule of law is nowhere more profoundly manifest than in our view that guilt shall not escape or innocence suffer. The public interest in criminal prosecution is particularly strong with regard to officials who are granted some degree of civil immunity because of their duties. It is in those cases where the public can see that officials exercising power under public trust remain on equal footing with their fellow citizens under the criminal law. See, and then another court case cited, we have never held that the performance of the duties of judicial, legislative, or executive officers requires or contemplates the immunization of otherwise criminal deprivations of constitutional rights. And then another court case, judicial immunity was not designed to insulate the judiciary from all aspects of public accountability. Judges are immune from Section 1983 damages actions, but they are subject to criminal prosecutions, as are other citizens. We emphasize that and then quoting another case, we emphasize that the civil immunity of prosecutors does not leave the public powerless to deter misconduct or to punish that which occurs. This court has never suggested that the policy considerations which compel civil immunity for certain governmental officials also place them beyond the reach of the criminal law. Even judges cloaked with absolute civil immunity for centuries could be punished criminally. That's a direct response to the chatter that was saying earlier, don't judges have infinite immunity? Oof. The public interest in the federal criminal prosecution of a former president alleged to have used the powers of his office to commit crimes may be greater still. The president represents all of the voters in the nation, and his powers are given by the people under our Constitution. Anderson v. Celebrezze. When presidents use the powers of their office for personal gain or as part of a criminal scheme, every person in the country has an interest in that criminal prosecution. The majority overlooks that paramount interest entirely. They don't ever address this, ever. I think this is a key point. Arguably the most important point that never even gets touched on by Roberts in the majority opinion. Finally, the question of federal criminal immunity for a former president involves a countervailing Article 2 consideration absent in Fitzgerald, recognizing such an immunity would frustrate the executive branch's enforcement of the criminal law. The president is, of course, entrusted with supervisory and policy responsibilities of utmost discretion and sensitivity. One of the most important is enforcement of federal law, as it is the president who is charged constitutionally to take care that the laws be faithfully executed. The majority seems to think that allowing former presidents to escape accountability for breaking the law while disabling the current executive from prosecuting such violations somehow respects the independence of the executive. It does not. Rather, it diminishes that independence, exalting occupants of the office over the office itself. There is a twisted irony in saying, as the majority does, that the person charged with taking care that the laws be faithfully executed can break them with impunity. Wait, real quick, okay? Now that I have a better understanding of law and composition of government, people were saying before that, like, well, what if the president doesn't enforce the law? What if Trump doesn't enforce blah, 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 blah? And then people were saying it could be a constitutional crisis. What is the constitutional crisis? Isn't the alternative just impeachment? Don't we have a direct remedy for it? Pissman going hard in the trenches. Uh-oh. The crisis is that impeachment will never happen. But that's not really a crisis, though, right? That's just your people have fucked you over. The people have failed at that point then, right? If impeachment doesn't happen and people don't vote accordingly, then it seems like that's not a constitution. Well, it kind of is, I guess. The people vote for legislators to pass laws and they continue to vote for them. But the legislators don't support impeachment, but the people continue to vote for the president. I guess that is kind of a crisis, huh? A little bit, sure. Care the laws, but okay. It does not, rather it diminishes that independence, exalting occupants of the office over the office itself. There is a twisted irony in saying, as the majority does, that the person charged with taking care that the laws be faithfully executed can break them with impunity. The case before us, the public interest and countervailing Article 2 interest are particularly stark. The public interest in this criminal prosecution implicates both the executive branch's interest in upholding presidential elections and vesting power in a new president under the Constitution, as well as the voters' interest in democratically selecting their president. It also, of course, implicates Congress's own interest in regulating conduct through the criminal law. Fitzgerald, noting that the case did not involve affirmative action by Congress, yet the majority believes that a president's anxiety over prosecution overrides the public's interest in accountability and negates the interests of the other branches in carrying out their constitutionally assigned functions. It is, in fact, the majority's position that boils down to ignoring the Constitution's separation of powers. Finally, in an attempt to put some distance between its official acts immunity and Trump's requested immunity, the majority insists that Trump asserts a far broader immunity than the limited one the majority has recognized. If anything, the opposite is true. The only part of Trump's immunity argument that the majority rejects is the idea that the impeachment judgment clause requires that impeachment and Senate conviction precede a president's criminal prosecution. That argument is obviously wrong. Rejecting it, however, does not make the majority's immunity narrower than Trump's. Inherent in Trump's impeachment judgment argument is the idea, yeah, true, because if Trump's argument was true, then you'd be saying, well, hey, listen, his official acts can still be criminally charged. They just have to be impeached first. But the Supreme Court, they say that, well, your interpretation is wrong, but also you can never be criminally charged with those acts, even if you are impeached, right? It actually goes further, really, but that argument is obviously wrong. Rejecting it, however, does not make the majority's immunity narrower than Trump's. Inherent in Trump's impeachment judgment clause argument is the idea that a former president who is impeached in the House and convicted in the Senate for crimes involving his official acts could then be prosecuted in court for those acts. See brief for the petitioner, and this is the brief then. The petitioner would be the person filing the case, which is going to be Trump, or in this case, Trump's lawyer. The founders thus adopted a carefully balanced approach that permits the criminal prosecution of a former president for his official acts, but only if that president is first impeached by the House and convicted by the Senate. By extinguishing that path to overcoming immunity, however, nonsensical it might be, the majority arrives at an official acts immunity even more expansive than the one Trump argued for. On the majority's view, but not Trump's, a former president whose abuses of power were so egregious and was so offensive, even to members of his own party, that he was impeached in the House and convicted in the Senate, still would be entitled to at least presumptive criminal immunity for those acts. Separate from its official acts immunity, the majority recognizes absolute immunity for conduct within the president's exclusive sphere to constitutional authority. We should write that down. Impeachment must proceed. It's precede, it comes before, not proceed, right? Precede any criminal indictment. Cannot be criminally charged. Separate from its official acts immunity, the majority recognizes absolute immunity for conduct within the president's exclusive sphere of constitutional authority. Feel free to skip over those pages of the majority's opinion. With broad official acts immunity covering the field, this ostensibly narrower immunity serves little purpose. In any event, this case simply does not turn on conduct within the president's exclusive sphere of constitutional authority, and the majority's attempt to apply a core immunity of its own making expands the concept of core constitutional powers beyond any recognizable bounds. The idea of a narrow core immunity might have some intuitive appeal in a case that actually presented the issue. This is similar to, I would argue, what Justice Barrett was saying. If the president's power is conclusive and preclusive on a given subject, then Congress should not be able to act upon the subject. In his Youngstown concurrence, Justice Robert Jackson posited that the president's power of removal in executive agencies seemed to fall within this narrow category. Other decisions of this court indicate that the pardon power also falls in this category. Quoting U.S. v. Klein from 1872, "To the executive alone is entrusted the power of pardon, and it is granted without limit, as does the power to recognize foreign countries." See Zivotofsky v. Kerry from 2015, holding that the president has exclusive power to control recognition determinations. In this case, however, the question of whether a former president enjoys a narrow immunity for the exercise of his core constitutional powers has never been at issue, and for good reason. Trump was not criminally indicted for taking actions that the Constitution places in the unassailable core of executive power. He was not charged, for example, with illegally wielding the presidency's pardon power or veto power or appointment power or even removal power. Instead, Trump was charged with a conspiracy to commit fraud to subvert the presidential election. It is true that the detailed indictment in this case alleges that Trump threatened to remove an acting attorney general who would not carry out his scheme. Yet it is equally clear that the government does not seek to impose criminal liability on the president for exercising or talking about exercising the appointment and removal power. If that were the majority's concern, it could simply have said that the government cannot charge a president's threatened use of the removal power as an overt act in the conspiracy. It says much more. The core immunity that the majority creates will insulate a considerably larger sphere of conduct than the narrow core of conclusive and preclusive powers that the court previously has recognized. The first indication comes when the majority includes the president's broad duty to take care that the laws be faithfully executed among the core functions for which a former president supposedly enjoys absolute immunity. That expansive view of core power will effectively insulate all sorts of non-core conduct from criminal prosecution. Were there any question, consider how the majority applies its newly minted core immunity to the allegations in this case. It concludes that Trump is absolutely immune from prosecution for any conduct involving his discussions with Justice Department officials. That conception of core immunity expands the conclusive and preclusive category beyond recognition, foreclosing the possibility of prosecution for broad swaths of conduct. Under that view of core powers, even fabricating evidence and insisting the department use it in a criminal case could be covered. The majority's conception of core immunity sweeps far more broadly than its logic, borrowed from Youngstown, should allow. The majority tries to assuage any concerns about its made-up core immunity by suggesting that the government agrees with it. That suggestion will surprise the government. To say, as the government did, that a small core of exclusive official acts, such as the pardon power, the power to recognize foreign nations, the power to veto legislation, and the power to make appointments, cannot be regulated by Congress, does not suggest that the government agrees with immunizing any and all conduct conceivably related to the majority's broad array of supposedly core powers. The government, in fact, advised this court to leave potentially more difficult questions about the scope of any immunity that might arise on different facts for decision if they are ever presented. That would have made sense. The indictment here does not pose any threat of impermissibility, criminalizing acts within the president's conclusive and preclusive authority. Perhaps for this reason, even Trump discouraged consideration of a narrower scope of immunity, claiming that such an immunity would be nearly impossible to fashion and would certainly involve impractical line-drawing problems in every application. When forced to wade into thorny separation of powers disputes, this court's usual practice is to confine the opinion only to the very questions necessary to decision of the case. There is plenty of peril and little value in crafting a core immunity doctrine that Trump did not seek and that rightly has no application in this case. Okay. Fuck, my voice is dying. Jesus.
I am not a church.
When asked about the allegations that RFK Jr. sexually assaulted his then 23-year-old babysitter, his answer,
I am not a church boy. I am not running like that. I said I had a very, very rambunctious youth. I said in my announcement speech that I have so many skeletons in my closet that if they could all vote, I could run for king of the world. Mm-hmm. So, this Vanity Fair is recycling 30-year-old stories, and I'm not, going to comment on the details of any of them, but...
give me the full interview real quick. I don't believe that this was his response to that specific question. There's no shot.
I am who I am.
You're talking there about the nanny situation. I mean, I do have to ask, sir. I mean, are you denying it or not?
I'm not going to comment on it.
All right. Well, I gave you the opportunity.
Have you ever debated Sagar and Jetty? No. I don't know how to pronounce his name even. I got a DM from this, I'll just say Beth. I don't even know who this person works for. About doing an RNC debate in Milwaukee on July 19th. What is this related to? Is there like an event or something? Or is it like a Republican thing? Or... I'm waiting for her to respond to that. But okay. All right. I'm going to shower and stuff and go downstairs and get ready for anything else. Wait, this is the interview?
Joining me now is
on a whitewater trip many years ago on the Fulaifu River, they say there's they have an expert that has identified that as a dog carcass.
Yeah.
It's just not true. So, and in terms of the other allegations, I've said this from the beginning. I am not a church boy. I'm
going to give you a chance running on short time.
I think it's $47,000, maybe $43,000 per donor. So it allows us now to go back to our donors and our maximum donors and tell them that that there's a new maximum. And so I think our fundraising is gonna be fine.
All right. Last question for you, sir, because I know that you're running on short time. Vanity Fair came out with a major profile today. I want to give you a chance to respond to this. There's a photo circulating, I believe, of you posing with what looks like a dog, and also a barbecue dog. I'm not going to show the picture. As a dog lover, I know you have pets yourself, and also a sexual assault allegation from one of your former nannies. So I want to give you a chance to respond to that.
Yeah. Sorry. The article is is a lot of garbage. The picture that they said is of me eating a dog. It's actually me eating a goat in Patagonia on a whitewater trip many years ago on the Futaleufú River. They say there's an expert. They have an expert that has identified that as a dog carcass.
Yeah,
it's just not true. So, and in terms of the other allegations, I've said this from the beginning. I am not a church boy.
Oh my God. It was actually the worst answer possible. He did answer it. He was presented with two allegations, a photo of you eating a dog and a claim that you sexually assaulted somebody. And his response was to specifically reject the dog eating allegation and then to hand wave the other one. Wait, why would you do that? Jesus Christ. He should have just given this response to all of the allegations instead of rejecting now I think he did rape somebody. Why would you do that? Why would you explicitly reject one and then just leave the other one hanging there?
I am not running like that. I had a very, very rambunctious youth. I said in my announcement speech that I have so many skeletons in my closet that if they could all vote, I could run for king of the world. Mm-hmm. So, this Vanity Fair is recycling 30-year-old stories, and I'm not, going to comment on the details of any of them, but I am who I am.
You're talking there about the nanny.
I am who I am. I mean, 30 years ago when he was 22, personally, I don't even, listen, I don't give a fuck. I don't care. I don't give a fuck. Well, I mean, if he full on raped somebody, I would give a fuck. That's pretty bad. But to just say that I'm a wild boy, I am who I am, I'm unapologetically me, and sometimes that just might be a rapist. That's a wild statement to make. Christ. Click on the picture of the dog eating? Nah, I don't need that shit. Okay. Thread explaining. Oh, do I want to read this Noah Smith thing? Thread explaining. For everything partisan coded, 80% of people will lie through their teeth to serve their tribe's goals, so it'll be hard to find an impartial summary of today's presidential immunity SCOTUS opinion. But I don't have a tribe, so here's my just the facts. Okay, I want to do this. Remember, this month we're being boring, so lots of reading, and I'm being better on my note taking. Hopefully, in the hopes that we can do better videos. So my goal after we finish reading the decision, I'd like to be able to do a video on it where I summarize the decision. I give good questions to ask for people that disagree with me, force them to answer these questions. Commentary on opposing points of view. I'd also like to include 3 different points of view that I want to address that I disagree with. So it'll be this. It'll be the Ben Shapiro video. Are you doing scripted content? No, it won't be scripted, but I'll just talk through it in a more, because right now it feels like the only way to get my opinion on any of this shit is go watch this 8-hour stream on the Supreme Court thing, basically, yeah. What am I looking for? Ben Shapiro, YouTube.
Well, last night was the first...
Jesus. Wait, did he change the title of this?
It was Justice Roberts who saved Obama.
SCOTUS makes a decision and the left goes insane.
Does not have immunity.
Probably has A/B testing on? Yeah, sure. Okay. How long is this? Fuck. Executive immunity has always been a thing. The underlying rationale is that presidents cannot be encumbered in carrying out their necessary official duties with fear they will be sued. Executive immunity has always been a thing. Excuse me, what? But immunity from what? Clearly, it hasn't always been a thing. If in Nixon v. Fitzgerald, the court had to grant it, and criminal immunity obviously hasn't been a thing if it was granted in this recent case right now. So I don't believe this is true. I don't know what he's sourcing to here. In terms of official acts, the president may act 1 with constitutional powers reserved, powers shared between or delegated by or 3 neither. Presidential immunity is strongest category 1, non-existent. Okay, this is who is this guy a lawyer? It's not strongest in category 1. It's absolute in category 1. What does this guy do? Attorney, programmer, student of life. Okay. He's just wrong here. I don't know if he didn't read or... Well, I guess if I'm being very technical, it is the strongest in 1 and the weakest in 3, or non-existent in 3. If by strongest you mean that's when it's absolute and unquestionable. That is the strongest thing, I guess, technically, I guess. Presidents have total immunity. Oh, okay, I'm sorry. He says it in the next thing. Okay. President, okay, so it is, never mind. He is correct. It's just a strange way to phrase that. Presidents have total immunity in category 1. Otherwise, it would give Congress and the judiciary power over the executive in an area where it is supposed to have exclusive power. This opinion focuses on category 2, where Congress delegates or shares power with the president. The other axis relevant here is whether proceedings are civil or criminal. The president's official acts, which encompass both categories, are absolutely immune from civil money damages lawsuits, well, from all civil lawsuits, right? In terms of criminal law, though, we have far less clarity. We have no clarity. SCOTUS today laid out the tension. The president needs to be able to act within the scope of the office. SCOTUS said today, taking into account these competing considerations, what is presumptive immunity? It's a presumption that a president is immune from criminal prosecution for official acts. But that presumption can be rebutted with a showing that prosecution wouldn't violate separation of powers. Wait, is it true that it wouldn't violate the separation of powers, or if you can show that it wouldn't encumber the executive to act? I don't believe this is true. I'll do a more formal go over this tomorrow, but I think this part is not actually correct. But SCOTUS today said, well, or maybe what he's saying here is another interpretation of what I'm saying, but SCOTUS today said the president has at least presumptive immunity. The majority said whether immunity here is presumptive or absolute is not a question that needs to be resolved today. In essence, today's decision kicks that can down the road. Up until now, I've only talked about SCOTUS opining on presidential immunity generally. What does that mean for Trump's case specifically? Well, this may seem strange, but nothing really? What? The key question for Trump's case is whether Trump's conduct around January 6th was official conduct. SCOTUS says the lower courts haven't adequately addressed that, and SCOTUS can't address the questions on its own initiative. It can only review lower court findings. And so SCOTUS goes on to analyze the alleged conduct to assess whether and what conduct qualifies as official conduct, but with the caveat that it can't do so comprehensively because it doesn't have a comprehensive record. SCOTUS addresses Trump's alleged conduct in 4 buckets: challenging election results in court, leaning on VP Pence to thwart certification, leaning on state officials and private parties to change state election results, and Trump's speech on and around January 6th. Bucket 1, SCOTUS says this conduct is absolute immunity. The executive is given sole authority to investigate and bring cases. If you could get around this by saying the cases were shams, every challenge to presidential judgment in bringing cases would claim as much. I don't like the way that he's summarizing number 1. I would full stop disagree with this. SCOTUS addresses Trump's alleged conduct in 4 buckets. 1 is challenging election results in court. That it wasn't about challenging election results. It was about appointing people in the attorney general role. It was about hiring and firing for his office, for his offices that are underneath him. It wasn't about challenging election results in court. The example given by Roberts was the threat to fire the attorney general if he didn't basically push a sham investigation through. So I disagree with the example given here. SCOTUS says his conduct has absolute immunity. The executive is given sole authority to investigate and bring cases. If you could get around this by saying the cases were shams, every challenge to presidential judgment in bringing cases would claim as much. This doesn't even make sense. The executive is given sole authority to investigate and bring cases. I don't even know what he's talking about here. I don't know where he got any of this from. I'm not sure I don't know what any of this means or where any of this comes from. Bucket 1, SCOTUS says this conduct has absolute... Okay, bucket 2, SCOTUS says VP presiding over certification is generally not executive function, but some VP acts presiding over Senate may be. SCOTUS instructed lower court to determine whether prosecution of these grounds would intrude on executive function. Says VP presiding over certification is generally not an executive function, but some VP acts presiding over Senate may... That's not really what he said, what Roberts said there either. Roberts said that... Roberts was talking about President Trump talking to Vice President Pence about the proceedings. Bucket 3, SCOTUS says president doesn't have authority over states' elections. They suggest finding me 10,000 votes and plots to replace state electors aren't immune, but they admonish the lower court for not giving them a full record to assess other conduct in this bucket. What? No? What? I don't think they admonish it. They remand it back to the court to do a factual finding to address which acts of Trump were official or not official. I don't think they admonish the lower court for that. This wasn't even a question that they would have known they would have had to address. Bucket 4, SCOTUS says some presidential speech is squarely official conduct. Other presidential speech isn't, and it's a very fact-specific inquiry, and so the lower court needs to do the fact-finding to determine precisely for each of the things Trump was alleged to have said. In sum, presidents are absolutely immune when investigating and bringing cases. Presidential immunity is shaky at best. It was about hiring. I don't know where I don't even know if Roberts ever even says investigating and bringing cases. It was about hiring and firing for the attorney general. Next, SCOTUS makes clear that if the court determines he has immunity for a given act, he cannot face criminal prosecution for the act. They also add that acts cannot be considered by the jury when prosecuting the president for other non-official acts. Finally, SCOTUS considers and rejects Trump's far broader argument for immunity. Trump's team argued that he can't be prosecuted for anything unless he is first impeached and removed for it. SCOTUS has no textual support for this argument. The Senate commentators all over social media are decrying this decision and saying that this decision would allow the president to assassinate his political opponents using SEAL Team 6. There's absolutely no support in the majority opinions for this. You're just wrong. SCOTUS could and likely will rule further on immunity, but I don't know I don't know if he like chat GPT'd the ruling and then gave his summary based on that. Because when did the ruling come out? Is this Twitter thread like an hour or two after the ruling was made? I don't know. Okay. Whatever. Okay. I'll see you tonight. Peace.